May I please look? Actually, with respect to item number 24, the counsel of the petitioners is stuck up in the jam law. Actually, requested me to take the matter after some time.
That yesterday's matter.
Yes, sir. Much.
May I please Lordship, with the consent of other party, I recommend item number 5 years.
5 years.
Yes, Lordship. In this regard, yesterday we have
Yes, sir, but these are old matters, 15 matters.
2015 matter, Lordship.
When can you do?
29th, madam.
Okay, 29th. Today is 20, okay, 29th. A prayer for adjournment has been made on behalf of Sri A.K. Purkast on health ground.
Yep.
Full stop. Para, considering that this matter is of the year 2015, comma, let it be listed. A matter is adjourned to be listed on 29/8.
Objection.
May I please, Lordship? Item, I beg to mention item number 10.
10 years.
Item number, as the learned counsel is out of session, so I pray for an adjournment. Lordship.
Who is the counsel?
5-6 is the preferable date, Lordship,
Who is
September.
the who's out of station?
Analog.
And along for the response number 5.
Right.
Inform the other side.
Yes, other side,
19 matter, why are you seeking time? Is out of station. Okay. When
out of session.
a request for adjournment has been made on behalf of Sri N. Alam, learned counsel for the response number 5. Para. List on admission on 3rd of September
5 or 6 September, preferable.
or 6th of September.
Deeply objection.
Yes, 6, 9.
May I please, Your Lordship? I beg to mention listing of a WBC my lord, 304/2024 my lord. Matter was last listed on 28/2024, pertaining to my lord state government employees my lord.
What is the subject matter?
My lord, the petitioner was employee of Tada Court my lord. After his retirement, on allegation of my lord overpayment of pay and allowance, some amount from his pensionary benefit was my lord recovered my lord. That was the matter my lord.
What is the urgency for out of turn listing? 24 matter.
My lord,
Sorry. This out of turn listing is only for urgent matters. Sorry. Next.
Please, Your Lordship.
Listing amount of na. It is Aziya sa nahi. Oh, no.
May I please, Your Lordship?
Yes.
I beg to mention for listing of 2 cases.
Just a minute.
On-
I think this is not the proper bench to mention for listing. There is a senior bench. Okay.
Is your Lordship, item number 4, it was fixed for today, Lordship.
Yes.
Mr. R. Muzumdar will be appearing, but he is stuck in traffic, Lordship, in Chanmari area, Lordship. Only for today, Lordship,
15 matter.
15 matter, Lordship.
Okay, we'll accommodate. Don't worry. If it doesn't come, we'll accommodate.
Obliged.
Let us pass here. It is submitted that Sri R. Mazumdar, learned counsel for the petitioner, is unable to come to the court due to some personal reasons. Full stop. Considering that the matter is of the year 2015, matter is adjourned to be listed on
Day after tomorrow, Lordship.
on 27th. 27th.
27.
Okay.
Obliged, Lordship.
May I
And
please,
your
Lordship?
Yes.
May I pray for listing of a motion matter?
I think
Tomorrow, Your Lordship.
listing matters are in code number 5, I think,
Court
as a
number-
senior bench. Bench 3.
Obliged.
नहीं वाला episode लो बोल लेना है वाला episode लो बोल लेना কাইলে করলেন, হ্যাঁ লোকেশ স্যার।
Please, my lord, for last date. Instruction was sought for from the responding.
Who's appearing?
Gayon. Gayon.
Lord,
He's on leave.
yes, Lord.
Will she be able to come otherwise also from that area?
If he has done to, Forest Sun, Lordship, Forest Sunset.
We'll have it after a couple of days, okay. Do Sri S. Sharma, learned counsel for the petitioner is present, comma. This court has been informed that Miss A. Gayan, learned CGC, is out of station. Put the para. In the interest of justice, a short accommodation is made directing listing of this matter on 29th, Thursday.
My lord.
But inform her, if she is not there, CGC, somebody else has to take charge.
May I take your lordship's indulgence for a moment?
Yes,
Bench is not sitting, your lordship, today.
you have for motion.
Most of
When?
it, tomorrow, your lordship.
What is the
Let's
urgency?
see, your lordship, relating to ongoing process of selection of public prosecutor. That has been going on.
Okay. Motion is.
Public.
Good bahana nahi flight from.
May I please your lordship?
Yes.
Lordship, my senior Mr. S.K. Mehdi is out of station. Yesterday he is supposed to come from Aizawl, but his flight was cancelled. Matter may be
15 matter, you're taking adjournment, difficult. Okay, when?
3rd of September.
Not 3rd of September. We'll have it on 27th of August. Tuesday.
He will be out of station. Lord. 2nd of September.
Not
Record is with us as per last court order. We call for the record from the department.
A prayer for adjournment has been made on behalf of Sri S.K. Mehdi, learned CGC. Para, as prayed for, list on 3rd of, 2nd of September.
Deeply applied.
May I please, lordship? Hello. My lord, in this case, lordship, a petitioner come before this court, lordship, against the lordship, penalty imposed on the petitioner, lordship. Lordship, input order is, lordship, page 28, lordship, kindly see.
28.
28, lordship, Annex 7, the input order, lordship. What it lordship? Lordship, last paragraph, after going for the explanation submitted by the UBC, DC Foods, Sumitla Day, I beg the disciplinary.
You
authority-
are unarmed constable.
Yes, lordship.
Petitioner.
Lordship, punishment is, lordship, his stoppage of the annual increment for 3 years with cumulative effect, lordship.
Hmm.
Lordship, fact of the case is that, lordship, kindly, lordship, lordship, petitioner files, lordship, serving at Pasram Police Station, lordship.
Hmm?
Pasram Police Station, lordship, as a UB constable, lordship.
Where?
Lordship, in the year 2015, lordship. After, lordship, his second shift duty, lordship, continuity, he went to his lordship quarter, lordship, which is situated at Pasram Peppermill Township, lordship. With lordship, the Pulsar bike, lordship, allotted to the police station, lordship, and parked it, lordship, outside of his lordship quarter, lordship. And after taking meal, lordship, he found that the Pulsar bike was missing from that place. Then, lordship, he lodged an FIR, lordship, with the Pasram police station, lordship. And Exar 1 is, lordship, is the FIR, lordship.
Page,
FIR one lordship, page lordship 18 lordship.
18, yes.
May I read lordship?
Not required. Then what happened?
Then lordship, the disciplinary authority lordship, thereafter lordship issued a show cause notice lordship, page 19, and I got two lordship.
What allegation?
Lordship, as per information report submitted by the OC Pasram Police Station on 2/1/2015, Lordship, body lordship, page 19 lordship, second paragraph lordship, and inquiry report submitted by the,
Oh, that was the department's motorcycle,
yes lordship,
not your personal
No, no.
motorcycle.
it is used by the lordship, Department of Police Authority lordship, from Thana lordship. Lordship, Hailakandi one so and so, while you are posted at Pasra, you went to HPC quarter with departmental motorcycle by registration number so and so. After completion of 7 shift entry duty at 4 p.m. for taking meal and kept motorcycle near your HPC's quarter at Pasgram. At about 7:45 p.m., you come out from your quarter and found that the departmental motorcycle was not available where you had kept. You had used the departmental motorcycle for your personal affairs, and your such negligence conducted careless handling for the motorcycle led to theft of the same from your custody. You
Okay, okay, we have read this.
lordship.
Then what?
Now, lordship, you are therefore charged, lordship.
Hmm.
Charged with gross negligence of duty and
That
misconduct.
we have read this.
Right.
Thereafter, what happened?
Then, lordship, I, lordship, filed a reply, lordship,
Yes.
because page 21, lordship.
21.
Lordship.
Yes,
May I read, lordship?
yes, reply.
With reference to the above, I have the honor to humbly and respectfully pray the following few lines with a assured high hope of receiving sympathetic order from your hand. That's our 1/2/1/2015. I was.
Okay, we have read this. Thereafter,
Then, lordship, disciplinary authority, lordship. Conducted inquiry, lordship.
hmm,
That is, lordship, inquiry report is page 22, lordship. Another 4, lordship.
okay.
Lordship. After the lordship inquiry, the disciplinary authority, lordship, in the last paragraph, lordship, page 23.
Hmm.
Statement of delinquent UBC Sumitlal there, he stated that he is now temporarily working as PSI Hailakandi post.
Hmm.
He was at PMG PS on that day, and he was detailed for second shift and sentry duty for the which perform his duties so and so lordship. Master lordship, he stated also. And ultimately, lordship, next paragraph, after careful examination of the prosecution witnesses and records, I find that theft of departmental motorcycle could be averted if it was handled by the delinquent constable with proper care, lordship.
Hmm.
He could easily kept the motorcycle inside the compound of his quarter, so negligence of the duty delinquent
Hmm.
is found proved beyond the reasonable doubt, lordship. Then, lordship, second shock cause notice was issued. Lordship.
Hmm.
It is a shock cause notice, lordship.
Hmm.
You are hereby informed that officer appointed to inquire into the charges framed against it connection with the departmental proceeding has submitted his report. On careful consideration of the report and perusal of the record, and having regard to the evidence and circumstances, I agree with the findings of inquiry officer and hold that charges have been proved against you beyond reasonable doubt. I therefore prima facie have come to conclusion that you should be penalized with a major punishment as per Rule 9 of the Assam Services Disciplinary Appeal Rules and executive lordship.
Hmm.
You are hereby required to show cause, if any, against the action proposed to be taken, lordship. Then, lordship, I filed my reply, lordship. Next paragraph, page 26, lordship. And exact 6, lordship. Then, lordship, I pray that, lordship, the incidents that took place, lordship, and lordship. Then, lordship, this info.com, lordship, imposing this major penalties, lordship. Lordship, stoppage of annual increment for 3 years with cumulative effect, lordship, which is not lordship prescribed penalties, lordship. As per rules 7, lordship, and lordship, Assam Police Manual, lordship, part 3, lordship.
Yes.
Lordship, this is lordship punishment, lordship, inflicted upon the lordship, the petitioner, lordship. Lordship, Assam Service and Disciplinary Appeals, lordship, rule 7, lordship, prescribed penalties, lordship.
Just a minute, please.
Lordship, kindly see, lordship, rule 7, lordship,
Just a minute, just a minute.
clause 3.
Yes.
For clause 1, lordship, censure, lordship, withholding of increment for promotion, recovery from pay of whole or part of pecuniary loss caused by negligence or breach of order to government or central government or any other state government, censure, lordship, reduction to a lower service grade or post or to lower time scale, lordship, or to lower stage in time scale, compulsory retirement, removal from the service, which shall not be dismissal from the service. There is no, lordship, the lordship penalties, lordship, stoppage or increment for 3 years with cumulative effect, lordship. Okay. Similarly, lordship,
No,
the
what about two? Two.
withholding an increment for promotion, lordship.
Or this is not off, this is or.
No, lordship, not or, lordship.
This is a printing mistake. Can be in the increment of promotion. Is there any expression? This is a printing mistake. You should understand. Withholding of increments or promotion,
Lordship,
not of promotion. Increments
withholding
itself
of increment of promotion, lordship.
of is it's an error in printing. It's or.
Lordship.
It is there.
Lordship, and so far as, lordship, the police manual, lordship, part 3, lordship, it is also said, lordship, major penalties, lordship, rule 66, lordship, police manual.
আসলে আমার পুলিশ ম্যানুয়াল কোন দেখা পুলিশ ম্যানুয়াল পুলিশ ম্যানুয়াল এনেকুৱা কিতাপত নহয় ডাঙৰ কিতাপ থাকিব বেৰেক নহয় অলপ ডাঙৰ থাকিব okay you can hand it over what does it say please
Lordship, penalties, lordship, rule 66, lordship,
which part
rule 66, lordship,
which part of the police
part
manual?
3, lordship.
Rule 66
Lordship.
yes what does
Plus
it
2,
say?
lordship, major penalties, lordship, dismissal from service which shall ordinarily to be the disqualification for future employment, removal from service which shall not be disqualification for future employment, compulsory retirement, reduction to a lower service grade or post or to lower time scale or to lower stage in time scale, recovery from pay of whole or part of any pecuniary loss caused by the negligence or whole of the part of any pecuniary loss caused by negligence or breach of order to the government of Assam or the central government, lordship. Now, lordship, here, lordship, thereafter, lordship, local government to whom service of a government servant had been lent, black mark, withholding an increment or promotion, lordship, censure, lordship.
Why don't you read the everything? It is the same rule, just in reverse order.
Lordship.
64.
Now, lordship,
penalty is just the reverse order.
now, lordship, there is a clause, lordship, that lordship, if any pecuniary loss, lordship, due
It's
to
not a
cost,
question of pecuniary loss.
lordship,
That is a different penalty recovery. It's a stoppage of increments. It is prescribed by the rules.
lordship,
That submission will not stand. If you want to make other submissions, you
lordship,
can.
lordship, now, lordship, lordship, so far as the lordship charge sheet is concerned, lordship, there is no charge sheet, lordship, at all, lordship. It is only show cause, lordship.
It is a so-called. How
Lordship.
does-
In this regard, I would like to,
how will the nomenclature change the nature?
lordship, I would like to, lordship, place on judgment of this honorable court, lordship.
Yes,
Lordship, this is writ appeal 104 of 2010, lordship.
yes. ডাঙৰ এখন আছে মোটা এখন নালাগে, এখন আছে বাৰু, দেখাব, ঠিক আছে, yes, সেইটো লাগিব। What is this?
My lord,
এখানে, এটা আছে, ঠিক আছে। এই পার্ট 3, রুল 66 টু সাইড, এই ধুলি আছে, মুছিলো।
my lord, for paragraph 2 লৰছি, I read it.
DDT 28/4/2010. Yes. Paragraph?
Honor lordship 7 lordship.
Paragraph 7.
My lord. It would be tried to say that disciplinary action would start on serving of the charge sheet.
Yes.
Prior to that, if any notice is issued to a delinquent employee to submit his say and explain his say, when those may be preliminary proceeding, but such proceeding cannot be considered to be initiation of the disciplinary proceeding. After receiving the reply to the notice dated so, if statutory, if authority was satisfied, then that would be an end of the matter. But in case of authority was not satisfied, that it could be proceeded after entering into the arena of the disciplinary proceeding by issuing appropriate charge sheet. It cannot be denied that a charge sheet was issued though particular though of a particular frame or form is not required, but the charge sheet must be cleared, understandable, intelligible, and unambiguous. The charge sheet should be supported by details of an allegation document on which the department is placed reliance last of oral and documented evidence. In present case, except allegation of a particular gross misconduct, nothing further was done in the matter. As perusal of the notice dated would clear that the respondent authorities were asked lordship appellant to show cause against the initiation of disciplinary action, and in fact, it was not charge sheet or notice to the appellant that disciplinary action has already been taken, lordship. Taking consideration the totality of the circumstances, we are unable to consider arguments submitted by the learned counsel for the respondent with all humility, expressing our inability to consider that finding recorded by the learned single judge, that judgment passed by the learned single judge is hereby set aside, all proceeding taken on respondent subsequent to the treating the said notice to be charge sheet is hereby quashed, lordship. Now here, lordship, and everything is, lordship, to submit show cause, lordship, as to why that so and so should not be imposed, lordship.
That is not definite.
Definitely,
Charges are not there. It is
Charges
not, it is not,
my lord,
it is not accompanied by a statement of allegation. It is not accompanied by a statement, list of witness, list of documents.
lordship. No, the lordship, there is the lordship.
Mr. Malaka, don't make this kind of arguments.
My lord, there is a
Arguments which
lordship,
have substance.
but is it
Use of
lordship,
nomenclature, how
lordship?
does it matter?
Lordship,
Whether
it
you
is-
call it a show cause or a charge sheet?
Lordship, it is the notice of show cause, lordship.
Yes, so cause to why?
Lordship.
Why penalty should not be, prescribed
Imposed,
should not be
lordship.
inflicted upon you?
Lordship.
On the following allegations. Allegations are there, come
Lordship.
turn over the page, statement of allegations.
Lordship.
These are not matters where you can base your ground. There are different grounds, it may be available, you are not urging those grounds.
Lordship,
On these grounds, where you won't, you cannot expect an interference, not at all.
lordship, I am lordship, there is a pecuniary loss, lordship, due to misconduct, lordship, and there is a lordship provision, lordship. Then if
They
lordship,
are not imposing that penalty of recovery.
lordship,
Is that the penalty of recovery? Recovery is not the penalty.
lordship, recovery, lordship, penalty, lordship, rule 7, lordship,
No, the penalty imposed upon you at page 28.
lordship,
Is it recovery?
recovery from pay or whole of pecuniary losses caused by the lordship.
What is the penalty imposed upon you?
Lordship, the stoppage of increment.
Is
for
it
3 years.
recovery?
Lordship.
It is not
But cumulative
recovery.
effect, lordship, this is the effective mind, lordship.
We should not go into the merits of the allegation, but still, you
Lordship.
use a departmental motorcycle, not a big problem. You park it outside the compound. You are negligent in parking. The
Lordship.
the bike is stolen.
Lordship,
Aren't you responsible?
No, lordship, it is lordship, established lordship that I park lordship outside my quarter, lordship.
Outside.
Lordship.
You should have put it inside. You could have averted this incident. A departmental vehicle of the police being stolen,
Lordship.
disgrace. And that too in front of your quarter.
My lord, lordship, if lordship, this community affect lordship, lordship. Lordship, department, lordship, recover the entire amount of the lordship, the losses lordship from my lordship.
We cannot,
Lordship, consider
into
this
those-
lordship aspect lordship is it.
anything else?
Lordship, lordship,
Yes, anything else?
in this lordship case, lordship, the respondent lordship, file lordship, affidavit lordship. In paragraph 6 of their affidavit, what they stated lordship,
Just a minute. R5,
type lordship.
R5, is it R5?
No, no, respondent to be here.
See in the cost title, how is it structured? Affidavit opposition by
R5 loss.
R5. R5, okay.
But-
What do you want to show here?
Lordship, paragraph 6 lordship.
Para 6.
With regard to the statement made in paragraph 5 of the writ petition lordship, my lord, what is the my lordship, paragraph 5 lordship in my writ petition lordship?
Hmm.
My lord, first may I read lordship paragraph 5 of my writ petition lordship. The superintendent of police director on receipt of the said replied it is so and so proceeded with the disciplinary proceeding against the petitioner and appointed Sri Kamal Chandra Borua, deputy superintendent of police, Halagandhi as inquiry officer in case without furnishing the formal charge sheet against the petitioner in accordance with the rules. The inquiry officer thereafter submitted the inquiry report details stating that the theft of the motorcycle could have been averted if it was handled by the petitioner with proper care, and he could have easily kept the motorcycle inside the compound of his quarter. And accordingly, negligence of duty by the delinquent is found proved without application of his mind to the evidence and materials in the case. In much as PW2, Pranjal Das lordship, in his evidence during inquiry stated that disciplinary proceeding was initiated against the petitioner based on the draft show cause notice issued to the petitioner during the investigation of the case. Now, the paragraph 6 lordship of the affidavit filed by the private.
Hmm.
With regard to the statement made in paragraph 5 lordship.
Hmm.
Here lordship, in paragraph 5, I have stated that the charge sheet was filed lordship.
Hmm.
Regarding the disciplinary proceeding. Here lordship, what stated? Paragraph 5, it is stated that under reliance of para 3, that person PS Krishna was also under so and so was registered against the unknown, not against the so and so. Hence, submission of charge sheet against the petitioner does not have. Now, lordship, I am stating lordship, the charge sheet was not filed lordship. This was not converted lordship by the respondent. Rather, they stated lordship, hence the submission of charge sheet against him does not arise lordship.
This reply is on the criminal case.
Reply on criminal, but my lord, my paragraph 5
You
lordship,
have understood them, still then you are trying to make out a case. Why?
lordship.
This charge sheet is with regard to the criminal case. You are the complainant, informant. Why should the charge sheet be against you? That is the reply.
Lordship, no lordship. Lordship, my paragraph lordship 5 is
We
regarding.
have understood your paragraph. You
Lordship.
said that even in the disciplinary proceeding, a charge sheet should have been
Hence,
against
lordship,
you.
they
We have
stated
seen the
that.
so called notice. It's in the form of a charge sheet. What expressions they are using will not make any difference if the contents are okay as per law. There is a statement of allegation, list of witness, list of documents.
Lordship, that is in lordship, after focus notice lordship, contents of allegation lordship, kindly see. After focus lordship,
Yes.
they state to a finding of inquiry lordship. Finding of inquiries.
Finding of inquiry was.
Yes, Lordship, finding of inquiry, place 22.
You read say, Rule 9 of the 64 rules, what is the procedure for imposing penalty?
Lordship,
The disciplinary authority shall frame definite charge
yes, Lordship.
on the basis of an allegation on which the inquiry is proposed to be made together with a statement of allegation and shall be communicated in writing. This has been done.
Lordship,
Whether they have used the expression show cause or charge sheet doesn't make any difference. Rather, in disciplinary proceeding, use of expression show cause is better. Charge sheet is confined to criminal cases.
now Lordship, the inquiry report, Lordship, they are, Lordship, after inquiry, Lordship, they are, Lordship, say, Lordship, the charge is proved, Lordship. In inquiry report, they have proved the charge, Lordship, before proceeding, proceed before the disciplinary authority, Lordship. Lordship, kindly, Lordship, this, after inquiry report, Lordship, they issued a second show cause notice, Lordship. It is a show cause notice, Lordship, not the charge sheet, Lordship, it's the second show cause notice,
Yes.
Lordship. Here, Lordship, show cause notice, Lordship, on careful consideration of the report and perusal of the records, having regard to the evidence and circumstances, I agree to the finding of the inquiry, Lordship. And Lordship, I hold that charges has been proved. It is the show cause report, Lordship. Not Lordship.
Mm.
finding-
And prima facie,
Lordship,
not holding prima facie. There's a use
the
of
major,
prima facie.
and prima facie
Mm.
have come to a conclusion that you should be penalized with a major
Mm.
punishment
Mm.
as prescribed to Rule 9 of the Assam Civil Service People.
Yes, thereafter,
Thereafter, I submitted my,
read.
you are hereby record to show cause, Lordship.
Yes.
Show cause, Lordship. Show cause, Lordship. After charge sheet, it is not a charge sheet, Lordship. Show cause notice.
This is the second show cause notice.
Second show cause.
Yes,
notice,
after
Lordship.
completion of the inquiry.
Lordship. So that Lordship, I submitted my Lordship on judgment, Lordship. That is what Lordship in our High Court, Lordship. If there is a Lordship show cause notice, Lordship, there should not be a charge, Lordship. This clear deal, Lordship, in Lordship. Lordship, Lordship, kindly see, Lordship, from paragraph 2, Lordship.
Which one?
Lordship, judgment of our Honorable Court, writ appeal number 104, Lordship.
Yes, we have seen this.
Lordship,
We have seen this.
Lordship, merit for from paragraph 2, Lordship.
This we have seen.
The appellant who was appointed as field assistant forest in Kacha Pepper Mill. Respondent corporation was served with a notice dated so and so to show cause as to why disciplinary action should not be taken against him for the alleged misconduct while described in the said notice. Being aggrieved by the said notice, the petitioner came to this court and contended that notice
We
to
have
show
seen this.
cause
We have
was
seen-
bad and
we have
this
read
is-
this, Mr. Malakar.
Lordship,
We have already placed this.
Lordship, departmental inquiry would not be opened for continuing the respondent before the submitted there. Notice dated so and so, in fact, was a charge sheet. And therefore, the respondent under the law were entitled to proceed with the appointment, Lordship. Appointment of the inquiry officer, here same, Lordship. After a hearing, the learned counsel for the parties, the learned single judge came to conclusion that though notice dated so and so observed that the reply explanation was sought for from the present appellant to show cause as to why disciplinary action should not be taken against him, but in fact, the said notice so and so was a charge sheet. After holding so, the learned single judge in paragraph 18 of the judgment observed as under Lordship. Having regard to the proposition, this court is of unhesitated opinion that petitioners assertion do not entitle him to relief sought for. The petition is in fact in the fact and circumstances of the cases is visibly premature and by way of reflects to the initiation of the disciplinary proceeding. The petition in the face of the above departmental.
Mr.
Yeah,
Malakar, this
Lordship.
challenge was initiated at the very moment when the show cause notice was given to him.
Lordship,
Here, the show cause notice has been, it's not, show cause has been, is accompanied by the statement of allegation. You have replied to it. Enquiry has started, enquiry completed. Thereafter, second show cause, disciplinary authority applies mine, imposes penalty. Penalty is the subject matter of challenge. How can you go back now?
now Lordship, Paragraph 4, no, Lordship, kindly.
Four we have read already. You have placed it four.
Lordship.
4, 7 you have placed.
Lordship.
These are matters of facts in that case.
Only Lordship, they have stated Lordship, it is a stopper's duties, Lordship.
That part we have noted. If there is anything else, please let us know.
Lordship, I am referring Lordship, this rule 7, Lordship,
Of the
Assam Disciplinary Appeal Rules, Lordship.
7,
Lordship, this, the penalty, Lordship, imposed, Lordship.
yes.
If Lordship is converted to Lordship, clause 3, Lordship, then a recovery from pay of the whole of the, for negligence, Lordship.
Our road is very limited,
Lordship,
very limited road.
already Lordship from 2015 Lordship till today Lordship. Yeah, increment of the Lordship.
Yes, anything else,
No, no.
madam?
Lordship, in this case, admittedly, Lordship, a motorcycle was stolen from the quarter of the present petitioner, Lordship. Lordship, then a proposal was issued to him. He replied to this. Thereafter, inquiry officer appointed Lordship, and everything was done as per rule, Lordship. And following all this, Lordship, inquiry officer submitted his report. Thereafter, order was passed and second proposal was issued before imposing penalty, Lordship. Thereafter, he preferred appeal. Then appeal also, Lordship. It was found that and
Appeal was
considering the entire facts, Lordship.
Where is the appellate order?
Appellate order is at page 32, Lordship.
Oh, this is appellate order also.
Yes, he contended on 3 grounds, Lordship. The impugned order dated 22/5/2015 as passed by SP Hailakandi in connection with DP number so-and-so is contradictory and divergent with the findings of the inquiry officer. Then SP Hailakandi, the disciplinary authority, without assigning any reason, inflicted major punishment. This is also one of the, then quantum of punishment, Lordship. Lordship, then the appellate authority considered everything, Lordship, and the DP records, these were also thin. Then in the conclusion, it was observed the appellant has been given enough opportunity to defend himself. All the established rules and procedures have been followed and principle of natural justice has been adhered to by the inquiry officer as well as by the disciplinary authority. The inquiry officer clearly and unambiguously opined in his findings. This is reproduced below. The negligence of duty by the delinquent UCB so-and-so is found proof beyond reasonable doubt. Hence, the impugned order dated 22/5/2015 in connection with DP case number so-and-so is not contradictory and divergent with the findings on the inquiry officer. Since the charges of negligence of duty, which constitutes the misconduct, has been proved in course of inquiry, so in my view, the SP Hailakandi incapacity of disciplinary authority has not made any error in inflicting major punishment on the appellant by this said impugned order. And the appellant is not only guilty of negligent act, but his such negligent act has caused financial loss to the department in terms of the loss of motorcycle. So the punishment inflicted by the disciplinary authority cannot be termed as disproportionate vis-a-vis to the misconduct committed by the appellant, Lordship. So this is there, and Lordship, in the affidavit also we have stated clearly, Lordship. He is telling about the charge sheet, Lordship. The police case was registered against an unknown person, Lordship. So it is nowhere the involvement of this person, but DP has been proceeded as because from his custody, Lordship, the loss was caused to the department, Lordship.
No, he is on a different footing.
Lordship.
He has understood it differently. He says that there was a necessity to issue a charge sheet to him in the disciplinary process, not a show cause. So it is this charge sheet he is referring. Your reply is with reference to the criminal case. That charge sheet cannot be given against the informant.
Yes, Lordship.
So that doesn't arise. But he is
Yes.
saying that show cause is not enough. There has to be a charge sheet in the disciplinary proceeding. A contention we are not accepting.
Statement is there.
Why not?
Lordship.
It's statement of allegation is
The
there. It's in
allegation is
the,
there, Lord.
it's in the proper
Along
format
with the
as
charge
per,
sheet.
as per rule 9 of the discipline.
Yes, as per rule of
Rule 9.
the Civil Discipline Appeal Rule.
That grounds we are
This
not
has been
accepting.
done. And he participated in the inquiry and it has been done fairly as it is evident from the documents annexed by the petitioner only, Lord.
Okay. Imposition of a penalty of stoppage of 3 increments with cumulative effect in a disciplinary proceeding which was affirmed in the departmental appeal is the subject matter of challenge in this petition filed under Article 226 of the Constitution of India. Para. As per the facts projected, the petitioner was working as a constable, bracket, UB, and relating to an incident of theft of a departmental motorcycle, which was in his custody, a disciplinary proceeding was initiated. Full stop. It is the case of the petitioner that relating to the incident, he had lodged an FIR on 3/1/2015 and thereafter, a show cause notice was issued to him on 25/1/2015. Full stop. The said notice was replied to by the petitioner on 6/2/2015 and being dissatisfied, an inquiry was initiated. Full stop. The inquiry culminated in a report in which the allegations against the petitioner was found to be substantiated. Full stop. Accordingly, on 6/5/2015, the second show cause notice was issued to the petitioner, which he had replied on 15/5/2015. Full stop. Thereafter, the impugned order dated 22/5/2015 was issued, imposing the penalty of stoppage of 3 increments with cumulative effect. Full stop. The petitioner had preferred a departmental appeal against the aforesaid order of penalty, which however was rejected by the appellate authority on 7/7/2015. Full stop. It is the legality and correctness of the aforesaid orders which have been put to challenge. Full stop. Para. I have heard Sri B. Malakar, learned counsel for the petitioner. Full stop. I have also heard Sri Miss M. Bhattacharya, learned students. Para. Sri Malakar, the learned counsel, has submitted that there was no negligence at all. And since his quarter was located at a distance, he had used the departmental motorcycle. Full stop. He has also submitted that immediately he had lodged an FIR on 3/1/2015. Full stop. On the issue of the procedure adopted, it is submitted that the show cause notice dated 25/1/2015 cannot be construed to be initiation of a formal disciplinary proceeding as no charge sheet was issued to him. Full stop. He submits that unless a formal charge sheet is issued, comma, no action can be taken on behalf, on the basis of a show cause notice. Full stop. The learned counsel has also drawn the attention of this court to the averments made in the writ petitions and the reply made by the respondent number 5 in the affidavit in opposition on the aforesaid issue. Full stop. The learned counsel has relied upon a judgment dated 28/4/2010 passed in WA 104 of 2010. Naam di diba, ha? Ralengtang Bangkang versus so and so. By referring to paragraph 7 of the judgment, comma, the learned counsel has submitted that a definite charge sheet is required to be submitted before proceeding with the disciplinary action. Full stop. Para. The learned counsel has also submitted that the penalty imposed is not prescribed either under the Assam Services within bracket Discipline and Appeal Rules 1964 bracket hereinafter the rules or the police manual. Full stop. He accordingly submits that the penalty has been imposed without any jurisdiction and is liable to be interfered with. Full stop. He has also submitted that the prescribed penalty also includes the penalty of recovery, and without availing the said option, comma, the present penalty of withholding of increment with cumulative effect has been imposed. Full stop. The learned counsel accordingly submits that the impugned action be interfered with. Full stop. Para. Per contra, comma, Ms. M. Bhattacharya, the learned student, has submitted that the entire action has been taken by following the due process of law. Full stop. She submits that there is no grievance with the procedure adopted in the inquiry in which the delinquent petitioner was given a fair and reasonable opportunity to defend himself. Full stop. As regards the submission that no formal departmental proceeding was initiated, comma, she contends that the show cause notice dated 25/1/2015 in clear terms reflects that a formal departmental proceeding was indeed initiated. Full stop. As regards the she has also submitted that the case law cited by the petitioner are based on certain facts which are distinguishable from the facts of the present case. Full stop. On the aspect that the penalty imposed is not prescribed by the rules holding the field, comma, the learned State Council submits that there is a clear stipulation of the aforesaid penalty in the rules as well as in the manual. Full stop. The State Council has also emphasized that the grievance of the petitioner was looked into by the appellate authority, and by a speaking order, the appeal has been rejected on 7/7/2015. Full stop. She submits that in a matter concerning a disciplinary proceeding, comma, the court would only look into the aspect as to whether the procedure was duly followed by giving a fair chance, and would not look and would not delve into the merits of the allegation. Full stop. Para. The rival contentions have been so and so. Para. The first contention of raised on behalf of the petitioner is that the issuance of the show cause notice dated 25/1/2015 would not constitute initiation of a formal departmental proceeding. Full stop. Para. He submits that unless the aforesaid submission is also supported by a further submission that unless a charge sheet is issued, comma, such initiation cannot be deemed. Full stop. Para. To examine the said submission, comma, this court has carefully looked into the show cause notice dated 25/1/2015. Full stop. The said notice in clear terms has stated that that the delinquent was required to show cause under the provisions of the Assam Police Act, comma, Assam Police Manual, and the rules of 1964 as to why penalties prescribed should not be inflicted on the charge framed. Full stop. Apart from there being a definite charge, comma, the show cause notice is also accompanied by a statement of allegation, a list of witnesses, and a list of documents. Full stop. Rule 9 of the rules of 1964 lays down the procedure for imposing penalties. Full stop. As per 9, within bracket 2, definite charges are to be framed on the basis of the allegations on which the inquiry is proposed to be held, and such charges, together with the statement of allegations, are to be communicated in writing by to the delinquent. Full stop. The show cause notice dated 25/1/2015 meets all the requirement as per the aforesaid rules. Full stop. In any case, comma, the use of the nomenclature show cause instead of charge sheet will hardly make any difference when the contents are adhering to the requirement of the rules, full stop. The reliance on the, upon reliance of the petitioner upon the judgment in so-and-so supra is misplaced, as the facts are wholly different and it is not discernible as to whether in that case, comma, the show cause notice was in adherence to the requirement of the rules holding the field, full stop. It may be mentioned that the appellant, that the petitioner in that case was an employee of the Hindustan Paper Corporation Limited, which has a separate set of rules, full stop. As regards the second leg of argument, that the penalties prescribed in the rules of 1964 and the manual, police manual, do not contain the penalty imposed, full stop. However, comma, a bare look in the rules as well as the manual would show that withholding of increments is specifically mentioned in amongst the penalties, full stop. The Learned Counsel has, and as regards the contention that recourse to the penalty of recovery could have been taken instead of withholding of increments, comma, this court is of the opinion that the aspect of imposition of penalty is wholly within the domain and ambit of the disciplinary authority. And this court plays a secondary role only to oversee as to whether the proceeding was carried out by following the due process of law, full stop. In a recent case of State of Rajasthan versus Bhupendra Singh, reported in 2024, 0 INSC 592, comma, it has been reiterated that in a disciplinary proceeding, there's proceeding, comma, a High Court in exercise of powers under Article 226 of the Constitution of India should not go for reassessment of the evidence and other matters which are within the domain of the disciplinary authority, full stop. There being no challenge to the procedure adopted, to the proceedings of the discipline of the inquiry, and this court being prima facie satisfied that the petitioner was given a proper and reasonable opportunity, comma, this court does not find any merits to interfere with the impugned action, full stop. Writ petition accordingly stands dismissed. Yes.
Okay.
P2 আর মোটর লেখা আছে INSC2 নতুন এলাম আইছে
Please, your lordship. Lordship, my senior could not come due to some difficulties, lordship.
Who is your senior?
Mr. J.K. Goswami, standing counsel, AIDC, lordship. There may be taken at any other day, lordship.
Mr. Kaur?
I think he has a genuine difficulty,
Okay.
Your Lordship, but very unfortunate. A hearing took place, almost judgment was dictated half way. And there's some difficulty, the matter was released from part heart because of the new notification of that 30 days. We may try it on a Tuesday.
Tuesday is a holiday, I think.
It's not this Tuesday,
On 29th,
29th.
what about 29th,
Just a word, madam.
Thursday?
Madam,
Lordship.
just a word. Madam, let it be subject to your lordship's convenience, 3rd of September.
Lordship, other than Tuesday, Lordship.
Huh?
Let it be on
Fifth.
Monday.
5th,
Fifth,
Fifth.
Lordship.
5th
Yes.
September, Thursday.
5th September.
A prayer for, no, whilst BD Kaur learned senior counsel is present for the petitioner, comma, a prayer for adjournment has been made on behalf of Sri J.K. Goswami, standing counsel AIDC. What's the para? Considering the above, matter is adjourned to be listed on 5th of September.
Lordship. Like,
This Look, there is another matter also in your lordship's court today.
Yes.
Madam, item number 19.
Yes.
My junior will be there, then that matter also let it come on 5th of the month.
50, okay. On a request made, raised, made by Sri BD Kaur, then senior counsel for the petitioner. Other side informed or not?
I have not seen them from the morning, but
We'll pass out in their presence.
yes, my junior.
Yes, somebody be there.
Yes, no. Not, yeah, yes.
250.
We have like.
Yes.
May please, Your Lordship.
Item?
Here in this case, today we have filed our affidavit.
Director has filed their affidavit by today itself only, madam. We have received the copy just now. She will kindly fix a short date, madam.
Okay, 2 weeks will grant you.
Madam, in the first week of-
Will
the
you
first
file,
week-
will you file reply or not?
No, madam, they have supported my case, madam.
Okay,
In fact, madam.
you take time to go through the affidavit, we'll fix
Madam,
it.
in the meantime.
Out Sri J. Hamad learned counsel for the petitioners who submits that the affidavit in opposition, that the copy of the affidavit in opposition has been served this morning. Full stop para. Sri Bora, learned standing counsel. This is education matter.
Education matter, provincial election service, madam.
You go before Sri Bora, the learned, top of the list. Okay, that is why it's. The learned Sri P. Bora, learned standing counsel education, submits, informs, has informed this court that the affidavit in opposition has been filed this morning, which however is not with the records. Full stop para. List on
5th of September, if possible.
6th of September,
My lord.
along with the affidavit.
Deeply obliged.
काय আহিব তো ভিন্ন material? Item. পিকে তো পি নহয় তো পিকে পিকে বল Yes, what is the matter? Madam, your name is this side kya?
Yes, Lordship.
I have just come with Mr. Kayal. He will argue the matter because he has got one husband also with him. I'll be with him to discuss.
No, we are waiting for both of you and Mr. Kyle.
That's right. I have talked with him.
He's coming or not?
He's in the court only. I'll find out now where he is now. I met him in court number 20. Now I again find out.
Madam, is he coming or what? You said he was coming.
Yes, Lordship.
Kayal is here. He's here.
No. She said that he's
Yes.
coming to the.
I called him.
Ah.
Please don't. I think I can.
Okay, fine then. We'll wait for that.
Then we call up some other matter.
Yes, Mr. Hello.
May I please the lordship? My lord, on last occasion, my lord, I apologize because I made a statement that there is a writ appeal pending pertaining to issue. Actually, my lord, that is a separate issue, my lord. That is regarding the retirement benefit, the Ayurvedic.
Oh, Kyle has come. Okay. Yes, now, Mr. Kyle, we'll
Okay,
taking
okay.
up your matter. No, what, are you taking up this matter today?
My lord, Mr. P. Nayak, appearing for the finance department, my lord, he is saying that they need some time to obtain instruction. They have not received instruction.
But last occasion, 13-8, we had heard the matter.
Yes, my lord.
Yes, my lord.
And
And on that occasion, your lordship asked me to obtain an instruction whether, my lord, this benefit has been granted to the teachers of the government Ayurvedic college. My lord, I have obtained the instruction. It has been granted to the teachers of the government Ayurvedic.
I have also
college.
instruction. They are getting.
Yes, my lord, they have been
no, the
granted.
other day, Mr. Halui was emphatically saying that they were getting.
Yes, my lord. So I have obtained a specific instruction. They have been granted, my lord. And regarding the petitioners also, my lord, the file was moved, my lord.
Since, Mr. Bora, since we have substantially heard the matter,
Yes.
let Mr. Nayak come.
Yes, my lord.
If he's got the instructions, otherwise we will give a very short date. We want to finish this matter. It's a old matter. Number
Yes,
one.
my lord.
Number two, we have given sufficient time in this matter.
Yes, my lord. I will call Mr. Nayak. my lord.
After a while.
Yes, my lord.
Mr. Kyle.
Lordship. May I please, Lordship? Lordship, kindly peruse the annexer F and annexer G, page 28 and 31, Lordship.
28.
Yes, Lordship. Page 28, annexer F. Lordship, here, the Chief General Manager of the Regional Office of National Highway Authority.
Just,
itself-
just a minute, please. Yes, what has happened?
Yes, Lordship. Lordship, here the annexer F, page 28, Lordship.
Hmm.
That is Chief General Manager of Regional Office, Guwahati National Highway Authority, Lordship. Itself requesting the higher authority, that is the respondent number 2, Lordship. That the file, yes, Lordship, that it in the representation, they have stated that the officer was on the para 2, Lordships, kindly peruse, Lordship. The
Hmm.
para 2, Lordship, the officer was on deputation from State PWD of Arunachal Pradesh to Uttar Pradesh, Lucknow,
Uttar Pradesh Rajya Krishi Utpadan Parishad from July 2003 and subsequently joined PWD Arunachal Pradesh in July 2006. After completion of deputation period of 3 years, the family of the officer stayed at his last duty station, that is Lucknow, since 2003 and presently also staying at the Lucknow. And para 3 Lordship, the family of the officer is not moved from Lucknow to during his move to Arunachal Pradesh any year. On July 2006, copy of certificate is to and the claim of for movement of the family to present duty station was not moved. And when the officer joined National Highway Authority on deputation, the copy of certificate as per the clause 3 of National Highway Authority order at para 1A clause para 3 the office memorandum para 16 above the benefits mentioned in 1 in A or B will also be admissible to central government employee who got the transport from the one station of the state union territory of northeastern region to another state. That is the para 5 the union view above that it recommended that the necessary extension of the competent authority be granted the additional house rent allowance to petitioner lordship. And the lordship para and the lordship annexer G page 31 lordship. Here, responsible for itself stated that still admitted that he is entitled. Lord.
When did you join the NHAI?
2011 lordship.
2011.
On deputation lordship. Yes, 2011 as per order dated as per his yes subsequent 2011 lordship 2011 lordship.
You joined
As
NHAI?
a manager, yes lordship, and as manager in the Lambing lordship.
Now, your claim would arise from the moment when you joined the NHAI.
Right.
Previously, you were in the state government, Arunachal.
Yes.
Now, while in that capacity, in 2003, July, you were deputed to Lucknow.
Yes, lordship.
For 3 years.
Yes, lordship.
After 3 years, in 2006, July,
Back
you
to
come
his
back and
Arunachal
join
Pradesh.
the
Arunachal
state government, PWD. Correct? And your family continued to stay at Lucknow.
Lucknow, lordship.
Now you joined NHI only in the year 2011.
Yes, sir.
If any right accrues, it will be after 2011. How will you get this period? The benefit which is given to a central government employee and also extended to employees under the NHAI will arise only when you are inducted in the NHAI.
Lordship, as per central government employee lordship, the additional house rent allowance is paid from the period of the 2011 to 31st May of 2011.
Okay.
After that, the respondent stopped this house rent allowance. Lordship.
You are asking after 2011, after you have
Yes, lordship, yes, lordship. That after we have filed various representation for house rent allowance, lordship.
When was it paid?
From 2011 to 31st May 2011, Lordship.
31st May 2011, this house rent paid.
Yes, Lordship. As per Annexure A, page 20, Lordship. After the Lordship, the responsible.
After 31/5/2011, the house rent has not been paid.
Yes,
Though your family is staying at Lucknow,
Lucknow.
then you should not emphasis on the first part. You can say that your family is staying at Lucknow. You are to join at Northeast, being inducted in the NHI in the year 2011. Initially, for 5 months, you were given house rent.
Yes,
Thereafter, it has been stopped. That
Yes.
is your case.
yes.
Why are you confusing with Arunachal Pradesh? That all those things, those are not required. Yes.
शक्ति पावर में एफिडेविट में कहते हैं पैराग्राफ 2 पैराग्राफ 4 लो एफिडेविट फाइल बाय वन आलोक कुमार
Page
page 2 paragraph 4
1 to 5.
paragraph 4 लो page 2
1 to 5.
yes doctor all the rest
Page 2, paragraph.
page 2 paragraph 4
Yes.
that with regard to the statement made in paragraph 2 of the writ petition, your deponent beg to state that after reverting to parent department, the PW Arunachal Pradesh, the petitioner was again released by Executive Engineer Papigat so as to enable him to join National Highway Authority of India. Had Executive Engineer's letter dated 17/1/2011. Therefore, it is established that the Pinakati had joined the NHI PIU Lambding within the same region. Then paragraph 5. That with regard to the statement made in paragraph 3 of the writ petition, your deponent beg to state that they are not correct and hence denied. It is to be submitted that last pay certificate sent to NHI from ex-engineer Pastigar shows that the petitioner was not drawing any amount on account of house rent at the time of petitioner's release. Further, it is stated that since the petitioner has been released from any state and joined on deportation to another location, that is PIU Lambding, also located in any region, is not entitled to get double HRA under the paragraph 1 of this petition of the writ petition, because this facility is only applicable to the people serving the department located outside the Northeast region. Then paragraph 6. With regard to the statement made in paragraph 4 of the writ petition, your deponent begs to state that the NHI PU Nagaon Lambding is of the view that since the petitioner is not entitled to get double HRA benefit as per NHI has already been stated in paragraph 5 of the petition. And Lordship may come to paragraph 9. That with regard to the statement made in paragraph 7, 8, 9, and 10 of and 12 of the writ petition, your deponent beg to state that they are not correct and hence denied. It is further stated that the LPC from his parent department has been issued by the ex-engineer PWD Pastigar, his last place of posting, which implied that the last posting place was Pastigat in Arunachal Pradesh. So the claim for paying HRA on account of posting at Lambding during his earlier tenure of the deposition is not tenable. And Lordship, my landment is relying on one judgment of His Honorable Court. We have clarified in paragraph 12. With regard to the statement in paragraph 14 of the writ petition, your deponent beg to state that the Honorable Judge filed delivering judgment on 22/4/2015 in WPC number 24 concluded in a reservation that on hearing the counsel for both the parties, I find that OM dated 2/1/2009 is not applicable to the petitioner does not have a right to get double HRA as the OM dated 2/1/2009 would not be applicable if the petitioner was posted outside the NH region in the Northeast region and his family continued to live outside the Northeast region accepted. And I'm kind of pleased to see the judgment is the next in the writ petition.
Yes, Lordship, here the case is different. Lordship.
Paragraph 46. Here, Lordship,
That case is different, Lordship. His family stayed within the northeastern region, Lordship. And in the HR is,
We'll come back to you. We'll come back to, let him finish, we'll come back to you.
paragraph.
Let him finish, you take your seat, we'll come back. to you.
Page
Yes.
51,
51.
Lordship. Last paragraph.
Yes.
On hearing the counsel for both the parties, principal. I find that OM dated 2/1/2009 is not applicable to the petitioner. The petitioner does not have the right to get double HRA on as OM dated 2/1/2009 would be applicable if the petitioner was posted from outside northeastern region into the northeast region and his family continued to live outside the northeast region. In the present case, the petitioner while living within the northeast region with his family was posted to another state within the northeast region. However, the respondent.
We have
was-
read this, the recovery has been said that you
Yes,
cannot
that-
recover, but he's not entitled.
He's not entitled to double payment because he was earlier, he was.
Here, have you recovered anything?
No, nothing.
Statement to try to support.
Yes, my learned friend is relying on this judgment.
In
In paragraph 14. And Lordship, I am relying on one judgment of Delhi High Court. Actually, paragraph 7 of the judgment, Delhi High Court. Okay, paragraph 7. I'm reading paragraph 7, Lordship.
Just a minute. Oh. Yes. Yes.
Merit. Paragraph 7. In view of the aforesaid contention, I have also carefully perused the content of the office memorandum dated 59 to 1998. The same relates to retention of general pool accommodation at the last place of posting by the Central Civil Service officer who are posted in Jammu and Kashmir. Therefore, what is stated in the state memorandum is that upon posting to Jammu and Kashmir, if there be any general pool accommodation provided with the petitioner at his last place of posting, the same could be retained by the employee after he is posted to Jammu and Kashmir. That, however, does not permit the petitioner to draw or get benefit of the house rent allowance at earlier place of posting. The petitioner would have been entitled for same if he would have continued to serve in the northeast region. So long as the petitioner was there, he had availed the said benefit of the house rent allowance, but upon his transfer to Jammu and Kashmir, the said benefit shall have to be forfeited as there is no specific provision in the rule and or in guidelines to continue to enjoy the said benefit even when he is posted to Jammu and Kashmir. In other words, when a person is posted to Jammu and Kashmir, he is not entitled to benefit of house rent allowance as that of a person who posted in northeast region, and therefore from the date of the petitioner was transferred to Jammu and Kashmir and posted there, he shall not be entitled to any house rent allowance. In the same manner as he was drawing while posting in northeast region, no provision could be pointed out by the petitioner for petitioner which entitled the petitioner to enjoy the same benefit even when posted to Jammu and Kashmir. So far as the office memorandum dated 59/1988 is concerned, the same is applicable only when the transfer and posting is on the place mentioned therein. Such benefit is not extended to transfer to Jammu and Kashmir. Therefore, I am the considered opinion that the petitioner is not entitled to receive the house rent allowance after he was transferred and joined Jammu and Kashmir. And here, Lordship, also, he is court directed it, whatever paid to him, that should not be realized. But if the analogy of this judgment in our case, but if earlier he was posted in Arunachal Pradesh, although his family is residing in Lucknow. Thereafter, on deportation, he was posted in Aita, in the same, from Arunachal Pradesh to state of Assam. And it is evident from the record that he was not drawing any house rent from the Arunachal Pradesh. So how he is not entitled to any benefit? Is there not?
Now, if the joining was from Lucknow to NHAI, matter would have been different.
Yes, that would have been.
He came back to the state.
Yes.
2006. From 2006 till 2011,
He was in
Arunachal.
Arunachal Pradesh.
Yes.
This is my point.
This case law you are citing will not help you. That has only interfered with the recovery part.
Yes.
Because the court had come to a finding that while making the payment, there was no fraud played by you. It
Yeah.
did not appear. Here also, perhaps we can go for, and they are not going for recovery. Are you going for recovery?
So this judgment is binding on.
But the respondent for itself requesting the higher authority for release.
No, that request will not be the law. We have to go. See, if your induction in the NHA would have been from Lucknow while you were working at Lucknow, maybe for deputation, then also they might have a still ground that was only a deputation. It was not a substantive posting. Substantive posting was all along in the state of Arunachal Pradesh. From Arunachal, you came to Lamding, Assam, within the northeast.
But his family is still in outside the northeast.
That will not make any. Your last pay certificate is of the state of Arunachal. If you are serving somewhere else, then posted in the northeast, matter would have been different. May not be a fit case, madam. Yes, Likha. The instant petition has been filed. Instant petition under Article 226 of the Constitution of India has been filed for the following relief. Page 17, quote. Para. As per the facts projected, comma, the petitioner was working as in the Public Works Department in the state of Arunachal Pradesh. Full stop. In July 2003, comma, he was deputed to the Uttar Pradesh Rajya Krishi Utpadan Parishad for a period of 3 years. And accordingly, the petitioner with his family had shifted to Lucknow. Full stop. The deputation was over, and in July 2006, comma, though the petitioner had come back and joined at Arunachal Pradesh, comma, his family continued to stay at Lucknow. Full stop. On 21/2011, comma, the petitioner was inducted in the National Highway Authority of India, within NHAI. Full stop. It is the case of the petitioner that for about 5 months, till 31/5/2011, the house rent additional house rent was paid for accommodating the family of the petitioner at Lucknow. Full stop. However, the same was stopped, and Ashoka's notice was issued as to why the amount should not be recovered. Full stop. Para. it is, parana, it is on this premises, comma, the instant petition has been filed. Para. I have heard Miss S. D. Saikya, learned counsel for the petitioner. Full stop. I have also heard Sri S. C. Kayal as well as Sri C. Barua appearing for the NHAI. Para. Ms. Saikya, the learned counsel for the petitioner has submitted that it is an admitted fact that the family of the petitioner is residing at Lucknow and the petitioner is posted in the northeastern region. Full stop. It is submitted that the additional house rent was rightly paid, rightly released to the petitioner for the period from January 2011 to May 2011, which was abruptly stopped, and the move to recover the amount is without any jurisdiction. Full stop. It is submitted that there is a specific letter and there is a communication dated 25/4/2014 by the NHA recommending such payment. Full stop. The learned counsel accordingly submits. No, the learned counsel has also relied upon a judgment of this court dated 22/4/2015, passed in WPC 6816 of 2013, within brackets Sunil Kumar Swenso, page 46 of our letter. The learned counsel accordingly submits that appropriate directions be issued for interfering with the action to recover the additional house rent, and also further direction be issued for payment of the same, including the arrears. Full stop. Para. Per contra, comma, the learned counsel for the NHAI, by referring to the affidavit in opposition filed on 16/9/2015, has submitted that the writ petition has been instituted on an erroneous presumption. Full stop. It is submitted that when the petitioner had joined the NHAI on 21/2011, comma, he was an employee under the PWD, comma, Arunachal Pradesh. Full stop. The last pay certificate of the petitioner, which is the relevant consideration, is of the state of Arunachal Pradesh. Full stop. It is reiterated, it is strenuously contended that though the petitioner was deputed to the state of Uttar Pradesh in the year 2013, comma, such deputation came to an end in the year 2006, 2013 or 2003 আছে না? এবার 2013 কইছো নাকি? না, না এইমাত্র deputation 2003 colon 13. 3. Such deputation was over in the year 2006, when the petitioner had come back and rejoined at Arunachal Pradesh, full stop. It is also contended that in any case, comma, the substantive posting was in the state of Arunachal Pradesh and cannot be construed to be a posting outside the posting at Lucknow, which is outside the state of outside the any region. Full stop. As regards the case law relied upon, comma, the learned counsel for the respondents has submitted that the aforesaid case would not come to the aid of the petitioner inasmuch as the OM dated 2/1/2009 was held to be inapplicable for the petitioner in that case, and only the recovery of the payment made was interfered. Full stop. The learned counsel has fairly submitted that even in this case, comma, the authorities would not insist upon the recovery for the payment made for about 5 months. Full stop. Para. The rival submissions. Reliance has also been placed upon a case of the Honorable Delhi High Court, namely so and so. Para. Address. The rival submissions have been duly considered. Para. The claim of the petitioner would relate back to an office memorandum dated 2/1/2009, which provides for granting additional house rent for persons who are posted in the northeastern region from any other part of the country. Full stop. In the instant case, comma, it is not at all disputed that the substantive appointment of the petitioner before he joined the NHAI was with the Public Works Department of the state of Arunachal Pradesh. Full stop. Though for a short stint of 3 years, comma, he was deputed to an organization in the state of Uttar Pradesh, comma, such deputation was over way back in the year 2006, whereafter he had come back and rejoined the Public Works Department in the state of Arunachal Pradesh and continued thereafter. Full stop. The induction of the petitioner in the NHAI was only in January 2011, in which the last pay certificate was taken into consideration, which was from the PWD, Arunachal Pradesh. Full stop. Under those conditions, comma, entitled the claim of the petitioner based upon the OM dated 2/1/2009 appears to be misconstrued. Full stop. Unless an incumbent can show that he has been posted in any region from a previous posting outside the region, comma, the entitlement for additional house rent cannot be countenanced. Full stop. Para. Para. As rightly pointed out by the learned counsel for the respondents, comma, the case law, the order dated 22/4/2015 passed in WPC 6816 of 2013 would not come to the aid of the petitioner, as even in that case, comma, the incumbent was held not to be entitled. Full stop. The communication dated 25/4/2014, by which a recommendation was made, would not vest any right to the petitioner, as the right has to be examined from the point of the objective of the office memorandum holding the field. Para, in view of the aforesaid facts and circumstances, comma, this court is of the opinion that no relief can be granted to the petitioner, and accordingly, the writ petition is dismissed, full stop. It is however made clear that no recovery should be made from the petitioner regarding the house rent, additional house rent paid for the period 21/2011 to 31/5/2011.
Much obliged.
Mr. Haloi. Somebody was it, Mr. Haloi? Where is he? Mr. Nayak, you are supposed to have instructed.
Last date, Lordship directed me to obtain some instruction, that is awaited, Lord. So, Lord, I'm basically praying for some time, Lord.
Okay. No, we had called the matter, you are not there. We'll grant you some time, but it's an old matter. Get the instructions early.
Lord.
And I think they may be entitled to prior facet, what has fallen from Mr. Bora. It seems that there is some lack of communication.
So, just two, three things, Lordship, I would like to point out. Lord.
And you take instructions. We are not hearing today. Since you are we are granting you time to have the do no. This court, by the last order dated 13/8/2024, had directed the Standing Council of Health Department as well as the Finance Department to obtain instructions, comma. Instructions have been received only by Sri Bora, the learned Standing Council Health Department, full stop. Para? No, para no. However, Sri Nayak, the learned Standing Council Finance Department, has paid for some more time to obtain the instructions, full stop. Para? In the interest of justice, list on, yes, they will have a date, whole matter.
On 6th, Lordship, 6th of September.
On 5th, whole matter, 5th,
Lord.
Thursday, on 5th of September.
Lord.
Please inform Mr. Haloi.
Yes, madam.
5th September. I go to the point.
Eight, please, Your Lordship. The matter relates to non-payment of salary, Lordship. Lordship, there was an order dated 31/7, Lordship. Observation was made, Lordship. And last sums was given, Lordship.
Health Department, where is Mr. Bora gone? Mr. Bora? Can you look for him? He was there. Mr. Talukdar, please call Mr. Bora. He was here in the court. DP Bora, Health. Health. Who is in charge, Mr. Bora? Mr. Gogoi is in charge, I think.
Generally, B. Gogoi appears.
His name is shown.
Yes, my lord, he will appear.
Mr. Bhuya, after a while, old matter will like to dispose this of. AC to na lage to.
Noted Mr. UK Goswami was continuing to dismiss their lordship. So may I inform him that the matter is related to dismissal from service that is prepared hearing. May I call him?
Records are here.
Of course, not everything is complete. Records not records, simple issue lordship. 22 matter.
Try to have him in the court.
Lordship.
Try to have him in
Yes,
the
yes, Lord.
Next, I said. Yet what is the issue, Mr. Goswami?
Malo.
Readings are over, changed.
Malo. Removal from service, Malo.
The simple issue is lordship that he has been removed from service on the grounds of lordship, indiscipline, lordship, misconduct and misbehavior. But that has not been proved.
But one aspect of the matter I have to, because before proceed, Malo, the relevant rule and act that will be necessary under enforcement that is not with me.
It should mean, it should mean.
Which act?
CRPF Act
CRPF.
1949 and this CRPF Rule 1955.
Yes.
We have those.
This is the petitioner herein.
Yes, sir.
Petitioner is a sepoy in the CRPF. He was inducted in the CRPF lordship in that on 27/5/2006 as a sepoy.
27.
5/2006.
Okay.
Then lordship, he was posted in different locations, and on 8/5/2017, he has been posted to 175 battalion, that is in Rani lordship at Guwahati. Till lordship
175.
8/5/2000, 175 battalion lord. During this 11 years of service, no adverse remarks, nothing were there against him. And then lordship, he continued to serve in since 2017 in Rani lordship, since 2017.
Yes.
On 16/1/2020 lordship, while posted at Rani, he applied for leave due to some lordship, dispute in the family lordship. He was under stress also, he applied for leave.
Yes.
But that leave was not granted to him without assigning any reason. They said that you'll be granted leave. You just go and get your ticket. He also even buy his air ticket also. But on lordship 17, thereafter on 17/2/2020, he applied on 16/1/2020 and 17/2/2020, he inquired about his status of leave because some persons who applied for leave after him, they were granted leave, but he was not granted leave. So he inquired over telephone to a lordship, the company Havaldar quartermaster.
Yes.
And on telephone lordship, when he inquired, then the CHQM, that is company Havaldar quartermaster, he abused him over telephone lordship. Then he objected to such lordship abuse. The petitioner objected to such abuse. But resulting that lordship, a memorandum of charge was issued lordship on lordship on 30/5/2020, which is at page 25.
30.
30.
Yes.
5/2020, which is at page 25. Thereafter, lordship, court of inquiry was directed to be conducted regarding the issue charges were framed. Then that is. Now, lordship may come to page 27, lordship.
Charges, you replied to the charges.
No.
You did not reply.
No, because After the memorandum of charge, he was given only 48 hours. That it is said in that memorandum of charge that 48 within 48 hours the any inquiry will be started. So in thereafter, lots of inquiry started.
Okay.
Inquiry officer was appointed and inquiry started.
Yes,
Page 27, my lordship may come to page 27 is the article of charges.
yes.
Wherein the charges, lordship,
27.
page 27. On 30 May 2020, lordship, the memorandum was issued and details this article of charges is at page 27, lordship.
Hmm. Yes,
The article, may I read the article 1, lordship? That post number so and so, Sipahi GT Vivas Chandra, while serving in 175 Battalion CRPF, consumed alcohol on 19/5/2020. During duty period, neglected his duty and misbehaved with other personnel. He was examined in the Rani CHC and on medical examination found him intoxicated, which is a punishable offense under provisions of Section 11(1) CRPF Act 1949, read with Rule 27 of CRPF Rules 1955 for indiscipline, misconduct, and misbehavior. That is during he consumed alcohol during lordship their duty and misbehaved with that. This is the first article 1, lordship. Next, article 2. This is also related to consumption of alcohol, lordship. Here, lordship said that post number so and so Vivas Chandra, while serving Sipahi in 175 Battalion CRPF, consumed alcohol on 17/2/2020. Their date is 17 to the first is 19/5/2020, lordship. During duty period and threatened CQMH, that is the company quarter Havaldar lordship, rank lordship, to throw acid on his face and also hurled abuse on the company clerk and CQMH, which is an offense punishable under Section 11(1) of CRPF Act 1941, read with Rule 27 of Civil Rules 1955 for indiscipline, misconduct, and misbehavior. Then lordship, article 3, which is the supplemental to the other two charges. It says that the post number 06 so and so is habituated of neglect or habituated to neglect duty by consuming alcohol during duty period. He was earlier counseled in respect of the consuming alcohol during duty period and also awarded punishment. Earlier he was punished also, but no positive changes took place of his conduct, which is an offense of disobeying of order, indiscipline, misconduct, and misbehavior under provisions of Section 11(1) of CRPF Act 1949, read with Rule 27 of CRPF Rules 1955. And it is against the high tradition and discipline of the force, and as such are punishable under law. These are the articles. Then thereafter, lordship, the inquiry started. The inquiry proceeding and the impugned order starts at page 34. It is dated, lordship, 28/9/2020. May I read that?
yes,
Office order, that is lordship, Office of the Commandant 175 Battalion, Rani Industrial Area, Kamrup, Assam, dated 20th September 2020. Office order. Pursuant to the provision 1 of this office memo number so and so dated 30/5/2020, a departmental inquiry was directed to conduct against post number so and so 175 Battalion CRPF under the provisions of Section 11(1) of CRPF Act 1949, read with Rule 27 of CRPF Rules 1955 on the following charges. Hide the office order memo number so and so dated 18/6/2020. Now, lordship, article of service. Same the article of service, lordship, it is repeated, lordship.
Hmm.
Then, lordship, page 36 is the witnesses. 8 witnesses were examined.
yes, yes,
Yes, page 36. 8 witnesses were examined, lordship. down below, Lordship. The findings, this is the findings and opinion of inquiry officer. This is the findings and opinion on the charges level against the accused person. Now, witness number 1.
Yes.
Prosecution witness number 1, force number Havaldar Ram Nivas, DHM, HQ 175. In his statement stated that from 18/5/2020.
This order is the penalty order.
This subsequently penalty order.
No, this one,
28/2020.
Yes.
Yes, penalty order. Here, all the PWs were examined. Everything has been eradicated. Yes. This is the impugned order.
Okay,
That's it. May I read?
please.
Here, Lordship said that the PW1 said in his statement stated that from 18/5/2020 to 19/5/2020. The article 1 was of 19/5/2020. Here it is said that from 18/5/2020 to 19/5/2020, Sepoy ZD Bibhas Chandra of 175 Battalion CRPF was on quarter guard duty and used to abuse over phone. That is very important, Lordship. He used to abuse over phone. Full stop. Whom he abused, nothing has been stated. The personnel was impressed upon and asked to take rest in the line, but he did not do so and continued to abuse on phone. It was reported by the SI to the adjutant 175 Battalion on 19/5/2020. Sepoy and on 19/5/2020, Sepoy ZD Bibhas Chandra 75 Battalion was brought to the force MI room, from where he was taken to CHC Rani and his medical examination was done, and as per report, he was intoxicated. It is the Lordship incident of 19/5/2020. And it is said that, Lordship, he was taken to the MI room or Rani CHC, where he was found to be intoxicated. It is said, but no such medical report has been annexed here anywhere, Lordship, in the affidavit also. I'll come to that later on, Lordship. Then, Lordship, the witness number 2, only 8 witnesses were examined. Witness number 2, it's prosecution witness number 2, post number so and so, Dilip Kumar Tiwari of DY Battalion, in his statement stated that on 19/5/2020, during marker in the morning, Havaldar Ram Nivas, this is the PW1, Ram Nivas. Havaldar Ram Nivas informed the Sepoy, informed that Sepoy Bibhas Chandra had been abusing someone on phone. It was PW2 was informed by PW1. The personnel was impressed upon and asked to take rest in the line, but he did not do so and continued to abuse on phone. It was reported to the adjutant 175 Battalion, and on 19/5/2020, Sepoy Bibhas Chandra 175 Battalion Sepoy was brought to the force MI room, from where he was brought to CHC Rani, and on his medical examination, he was found drunk and the medical report was submitted to the adjutant. Now, Lordship, again, PW3. PW3 post number so and so. He was also informed over phone by PW2. Lordship. PW3 post number so and so, Bhaskar Deka, DI Battalion, in his statement stated that on 19/5/2020, during marker in the morning, to DI Dilip Kumar Tiwari, PW2, his PW2, Lordship. I was informed over phone that Sepoy ZD Bibhas Chandra is suspected to have consumed alcohol, and it was arranged for medical examination of Sepoy ZD Bibhas Chandra, wherein he was found drunk. Then PW4, Lordship. He is stating, Lordship, the PW4 states that PW4, prosecution witness 4, Havaldar ZD Jitendra Singh, CHM Battalion, in his statement stated that on 19/5 during marker, 19/5/2020, during marker in the morning, Sepoy Bibhas Chandra of 175 Battalion CRPF was abusing on phone. Again, he is saying abusing on phone. He was on quarter guard duty from 18/5 to 19/5/2020. On 19/5/2020, pursuant to the direction of the adjutant, the personnel was brought to CHC Rani, and on his medical examination, he was found drunk. Then, Lordship, witness number 5. This is the main witness, Lordship, with whom, Lordship, the petitioner was talking over telephone. Prosecution witness number 5, number so and so, ZD Havaldar ZD K. Jai Sinha, CQMH C 175 Battalion, in his statement stated that while I was discharging my duty in CQMH C 175 Battalion, Sepoy ZD Bibhas Chandra called me and by using swearing words kept abusing me and said that he will throw acid on my eye and on Havaldar Tutan Banik and said that by killing me he will change the history of the CRPF. I have recorded the same on my mobile. He has recorded it also. And informed the company adjutant Havaldar and Havaldar Tutan Banik about it. He lordship abused, as per the statement, lordship, he abused the PW5 and stated that he will throw acid on some other person, that is Tutan Banik. He has also been examined here subsequently. On 17/2/2020 at 17:30, the delinquent again consumed alcohol and misbehaved with the personnel on duty. The delinquent was taken to Guwahati for medical examination and medical report was submitted to the company commander. Here, the medical report of 17/2, they have annexed with their affidavit. But on 19/5, nothing has been annexed with the affidavit or on record. Now, let's see PW6. Prosecution witness 6, number 6, Havaldar Tutan Banik. He was, the PW5 was told that over telephone that he will throw acid on Tutan Banik also. But he never called Tutan Banik. Tutan Banik of company clerk C-175 battalion in his statement stated that on 17/2/2020 at 13:15 p.m. Havaldar K. Zayasinha, this is PW5, told me that Sepoy ZD Vibhas Chandra called him and abused him, saying that he will throw acid on his and Havaldar Tutan Banik's eye. Havaldar ZD K. Zayasinha asked the delinquent what is the problem and why he is behaving such a way. Since nobody was prevented him to go on leave, the delinquent did not hear the single word of him and kept abusing him, so he recorded his calls and submitted to the company commander. On the order of the commander, he was removed from the security in the quarter of special IGP and detained in Guwahati Hospital Mental Department. On 17/2/2020, the delinquent again consumed alcohol and misbehaved with the personnel on duty. But whom he misbehaved on personnel, nothing has been stated here. Havaldar ZD K. Zayasinha and company adjutant Narasingha Meena had taken the delinquent to Guwahati for medical examination and medical report was submitted to the company commander of force. Nothing, no medical report on record. Okay. On witness number 7. Prosecution witness number 7, Narasingha Meena battalion stated that on 17/2/2020, K. Zayasinha, that is PW5, Lordship, told me that he was also informed by PW5, told me that Sepoy ZD Vibhas Chandra, who is at present detailed in security of the quarter special IGP for 24 hours, called him at 13:15 p.m. and abused him, saying that he will throw acid on his and Havaldar Tutan Banik's eye and shoot all of them. The delinquent did not hear a single word of Havaldar K. Zayasinha and kept abusing him. Following the order of company commander, company C-175 battalion, company Sepoy ZD Vibhas Chandra was called in the company office with guard commander. Sepoy ZD Vibhas was removed from security in the quarter special IGP and detailed in the Guwahati Hospital Mental Department. On 17/2/2020, the delinquent again consumed alcohol and misbehaved with the personnel on duty, about which the company commander was informed. Following the order of the company commander, the delinquent was taken to Guwahati for medical examination and medical report was submitted to the company commander. Now, last witness is Lordship, PW8, Lordship. Prosecution number PW8. The Ajay Shekhar, assistant commander, stated that he was serving as company commander, the 175 battalion, company 170 battalion. On 17/2/2020 at 13:15 p.m., Havaldar ZD K. Zayasinha told me that Sepoy ZD Vibhas Chandra called him and abused him, saying, that is telephonically called him, not called him and abused him, saying that he will throw acid on his and Havaldar ZD Tutan Banik's eye and change the history of the CRPF by killing them. Immediately, I ordered company ASI Narasingha Meena to bring force number so-and-so, Vibhas Chandra, before me and to check his luggage. Thereafter, when I asked Sepoy Vibhas about aforesaid misbehavior and about his problems, he aggressively replied and stated about his going on leave on 22 22 to 2020. I said him about sending him on leave as per his schedule and ordered to remove him from the security in quarter special IGP region and detailed in the Guwahati Hospital Mental Department. On the same date, post number so-and-so Vibhas Chandra, after his duty in Guwahati Hospital Mental Department at 7:30, again consumed alcohol and misbehaved with the other personnel on guard. For this post, Sipoy Vibhas Chandra was sent to Guwahati for medical examination, examination with Narasimha Meena. After receipt of the medical report, Vibhas Chandra was sent to company editor Narasimha Meena to Guwahati for medical examination. On receipt of the medical report on 18 to 2020, GD Vibhas Chandra was sent to the headquarters with special report and movement order. These are the lordship the witnesses who stated that, or except PW5, everyone was informed by PW5 that he abused him over telephone. Now, lordship, the inquiry officer opinion and come to the finding. This is important. Now, opinion of the inquiry officer. It says, from the aforesaid facts, it is proved that the delinquent during his duty period consumed alcohol in time to time, and for such indiscipline act, he was also awarded punishment. So, lordship, the first that findings that the inquiry officer come to the findings that he consumed alcohol during service, and he is also habituated. Next, lordship, the findings is he is also habituated to remain absent from duty without permission, which is an act of indiscipline. Lordship, this second finding, that conclusion that comes by the inquiry officer, this was never a charge for which the inquiry was conducted. His absence, habituated absentee, if this is a foreign charge which has been taken into account for giving the punishment. Therefore, the charges imputed in Article 1, 2, 3 against the Sipoy Vibhas Chandra are established beyond doubt. Though, lordship, that a foreign charge was taken into account while giving punishment, it is said that it is established, the charges are established beyond reasonable doubt. Thereafter, lordship may come to page 44. This is the observing. Page 44.
Just a minute.
Paragraph 9.
Just a minute. Page 40.
44. This is a continuation of the lordship.
Yes.
9, lordship. On perusal of the departmental proceeding, statements of the witnesses, and the report of the inquiry officer, the undersigned found that the department proceeding was conducted following the due process of law. During the inquiry proceedings, statements of the witnesses were recorded in presence of the accused, and the accused was given sufficient time to make his statement and to defend himself at every stage of the proceeding. Therefore, after giving deep consideration, it is found that the charges brought against the accused in the Article 1, 2, 3 have been fully proved. He was given opportunity, 15 days opportunity was given, lordship, to file, but he did not file reply, lordship. So, next paragraph. Therefore, as a disciplinary authority in exercise of power vested under provisions under of Section 11(1) CRPF Act 1949, read with Rule 27 of CRPF Rules 1955, I am hereby passing the following orders against so-and-so Sipoy Vibhas Chandra, 175 Battalion, on the basis of the inquiry report. A, post number so-and-so Vibhas Chandra Battalion is awarded the punishment of removal from service, which will be effective from 39/2020. So this is the punishment of removal from service. Now, lordship, the basic, lordship, the findings, on 2 findings, their punishment has been given. Lordship, once again, I would like to take lordship to the findings and opinion, lordship, of the Act 41, wherein initially said that from the aforesaid fact, it is proved that the delinquent during his duty period consumed alcohol in his time to time and such discipline. Lordship, in the CRPF Act, there is no provision for giving punishment for consuming alcohol, but there is a provision if the person is found to be intoxicated, then lordship, he will be punished. So lordship may lordship to the CRPF lordship act lordship. It's a rule, a section 10.
Yes.
The heading of section is less heinous offense. Lordship.
Hmm.
Every member of the force who is 10A lordship is in state of intoxication when on or after having been warned for any duty or on parade or on line or march or lordship. These subsequents are not relevant. Lordship, the page next lordship shall be punishable with imprisonment for term which may extend to 1 year or with fine which may extend to 3 months or more. Lordship, last lordship.
Yes.
After P, after 10P, Lord.
After
For
10,
this, for all these offences, there is shall be punishable with imprisonment for term which may extend to 1 year or with fine which may extend to 3 months.
yes.
So here the lordship, that punishment is for intoxication and not for alcohol, taking alcohol while in duty. But if he is found that he is in a state of intoxication during duty, then he will be punished. Regarding this has been lordship, this issue has been clarified by division bench of the lordship Manipur High Court, which has categorically stated that during discharging duty during alcohol by consuming alcohol is not a punishment. It's a lordship punishment. That punishment is not lordship in terms of the provisions of law. The fact here is the more grievous or more serious than the instant petition. That paragraph 2, that is a division bench or judgment lordship.
Yes. What?
Paragraph 2 is the fact of the case. It is important here. May I read that? First paragraph.
Can I come to the finding here?
Finding lordship, I'll come to that because this is also important, because the grievance here is lordship more serious than the petitioner. Only a few lines. Even here, after consuming alcohol, he cocked the rifle also in this case.
Yes.
Then lordship may come to page paragraph 9. It's relevant.
9.
May I read?
Yes.
9. Even otherwise also, while examining the inquiry report, it has been noted that though the inquiry officer had come to a finding that the petitioner was under the influence of liquor, no finding has been made that the petitioner was in a state of intoxication, which is a specific offense, bracket, a less heinous offense as mentioned under section 10A of the Central Reserve Police Code Act 1949. In this regard, one may refer to section 10 of the Act, which relates to as follows. 10 has been quoted, lordship, and lordship in the last, it is stated in the last line, lordship, shall be punishable with, in case of intoxication, shall be punishable, same lordship in the same page. In case of intoxication, shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which may extend to the 3 months pay, or with both. Then lordship, paragraph next page. Consumption of that, this has been lordship discussed here. Consumption of liquor while on duty is on one thing, and conclusive finding that because of consumption of liquor, the petitioner was in a state of intoxication while on duty, and petitioner's normal capacity to act was inhibited and adversely affected, and the nature of duty had been compromised, putting the individual or the organization at risk, is another thing. Consumption of liquor while on duty as per the CRPF Act is not per se an offense unless one is in a state of intoxication while on duty. there is no finding to the effect that the petitioner was in a state of intoxication and exposed the organization to any kind of risk. The finding order rendered as in subpara 3 of the analysis and assessment of evidence is that the petitioner had consumed liquor while on duty. There is no finding by the inquiry officer that because of consumption of liquor, the petitioner had behaved in a manner which had seriously breached the safety and security of the organization. There is neither any finding that the petitioner was found in a condition of drunkenness or inebriation and was incapable of performing his sentry duty. Then paragraph 10 is important topic. Paragraph 10. It is to be noted that as per the article of charges, the petitioner at the relevant time was alleged to be under influence of liquor. Therefore, it may be necessary to understand the meaning of the expression under influence of liquor, so as to appreciate the charge leveled against the petitioner, and which have been held to be proved by the inquiry officer, and the punishment imposed upon him based on that charge. Next paragraph. It may be noted that under CRPF Act 1949, the under influence of liquor itself has not been specifically mentioned as an offense or misconduct. What has been prohibited and specified as an offense is to be in a state of intoxication when on any duty, as mentioned in section 10A of the Act. In other words, if the petitioner was charged of being in a state of intoxication when on duty, the department had to prove the same and could legitimately impose any penalty upon the petitioner. However, the petitioner has been charged of being under the influence of liquor while on duty. As to the meaning of state of intoxication, since it is not defined under the CRPF Act and rules framed thereunder, one may refer to provisions of Penal Code 1860. Get a clue of its meaning from section 85 of the Penal Code 1860. Section 85 of the APC reads as follows. Section 85. Act of an person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who, at the time of doing it, is by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. As per this section, if a person is incapable of knowing the nature of the act, or that he is incapable of knowing that what he is doing is either wrong or contrary to law, he can be said to be in a state of intoxication. Intoxication has been defined in Black's dictionary as follows. Intoxication term comprehends situation where, by reason of taking intoxicants, as individual does not have the normal use of his physical or mental faculties, thus rendering him incapable of acting in the manner in which an ordinary prudent and the cautious man in full possession of his faculties, using reasonable care, would act under like conditions. Now let's see, next para is page 17. Sorry, paragraph. No, Lordship, next page, Lordship. Next. Therefore, it starts with therefore.
Yes.
Therefore, if to be under influence of liquor while on duty is to be treated as an offense or an act of indiscipline, he must be attributed with such acts which he would commit when in the state of intoxication. In order to penalize a person of being under influence of liquor, he must be in a state of intoxication because of consumption of liquor, so as to render him incapable of knowing the nature of his act or to understand what he is doing is wrong or prohibited by law. In the present case, for the department to penalize the petitioner on the charge of being under the influence of liquor, it has to be shown that the petitioner was not capable of knowing what he was doing, or that he was not aware that what he was doing is either wrong or contrary to law under the influence of liquor. It is to be noted that to be under influence of liquor describes that the state of mind or body which indicates that he was acting in a manner which a normal person would not otherwise behave except under the influence of intoxicating liquor. However, the inquiry report nowhere mentions or discusses any evidence or findings to the effect that he was in a state of intoxication or that he was incapable of knowing what he was doing or was not aware that what he was doing is wrong or contrary to law or that he was behaving in a manner which would clearly indicate that he was in a state of drunkenness or inebriation to be described as under influence of liquor. What has been recorded in the inquiry report and the analysis and assessment of the evidence is to the fact that the petitioner had consumed liquor while on duty. It may be also observed that the fact that the petitioner cocked the rifle does not itself indicate that he was drunk or it was an act committed in a state of drunkenness. It also cannot be said that he was in a state of intoxication as he never aimed his rifle to the patrolling party. This court is of the view that the fact that he cocked his rifle but pointed the barrel towards the sky does not in any case indicate in absence of any other evidence that he was in a state of drunkenness or intoxication so as to render such an act being perpetrated under the influence of liquor. Therefore, this court holds that the drawing of inference and conclusion by the inquiry officer that the petitioner had acted in a indisciplined manner under influence of liquor does not seem to be based on any cogent material. So this is the observation of the in paragraph 10 of the Honorable Court, Lordship. Now, Lordship may come to paragraph 16, Lordship.
Yes.
Paragraph 16. We are also of the view that the punishment meted out to the petitioner of this is the disproportionate punishment that is
Dismissal.
given. We are also view that the punishment meted to the petitioner of the dismissal from service is too harsh as against the charges said to have been proved, considering the circumstances as revealed in the case. It is not the case of the department that the petitioner had failed to do his sentry duty or that he deserted the post, thus exposing the organization to serious risk. What is alleged against him is that it was him that though he had performed sentry duty on the fateful day in place of another personnel, it was without obtaining permission from the competent authority, and he was under the influence of liquor. As discussed above, neither the person in whose place he performed sentry duty was examined, and the said person continues to be in his service. In fact, the said person was let off with a lesser penalty by taking a sympathetic view. This is in relation to this specific case. View, which sympathy, however, was not shown to the petitioner. Now, the petitioner did not did the sentry duty under an emergent circumstance at that request of the said person, which has not been controverted by the authority. Further, consumption of liquor per se, and even if proved without being in a state of intoxication, without compromising with the security and safety of the organization, cannot be considered too serious to invoke the penalty of dismissal, the ultimate penalty as provided under the rules. Then paragraph 17.
Yes.
As regards to the other allegation against the petitioner that he cocked his rifles and pointed towards the patrol party under the influence of liquor is not proved. This is not related to the specific to this. And the judgment, the findings of the Honorable Court. Paragraph 18.
Yes.
Since the court has come to the conclusion that the inquiry report suffers from a fatal flaw and cannot be sustained, and also that the punishment meted to the petitioner is shockingly disproportionate to the charges proved under normal circumstances, this court would have remitted the matter back to the disciplinary authority to start the inquiry from the stage of submission of inquiry report and also direct the authority to consider the quantum of punishment. However, as discussed above, the charges against the petitioner are not complicated, entailing complicated facts and involving complicated questions of law, but simple instance of consumption of liquor while on duty, doing sentry duty in place of another constable without permission from the authority, and cocking of his service rifle. Since the petitioner has also admitted to have performed sentry duty in a place of another of his colleague without permission of the appropriate authority, and we have already held that the charges that he was under influence of liquor has not been proved, and also in view of the evidence as reflected in the inquiry report, that though the petitioner had cocked his rifles, it was pointed towards the sky, which the petitioner himself also do not deny. And since the incident occurred on 18/7/2011, and having regard to the penalty imposed on the other person, NG so and so, we are of the view that rather than referring the matter back to the authorities to start the departmental inquiry afresh, as indicated above, we deem it fit and proper that we remit the matter to the authorities for the purpose of deciding afresh the quantum of punishment, so that the authority can impose any other lesser punishment to the petitioner other than the dismissal, removal, or compulsory retirement from service. In the result, the repetition is allowed. The dismissal order dated so and so, as well as the order issued by the appellate authority dated so and so, dismissing the appeal preferred to the petitioner are quashed, and we remit the matter to the authority to decide the quantum of punishment to be imposed on the petitioner other than the penalty of dismissal, compulsory retirement from service for the reasons discussed above, which may be done within insurance. So here also the one of the ground taken by the inquiry officer for giving the punishment was the consumption of alcohol, which has been in the CRPF Act. There is no provision for giving punishment for consuming alcohol during that. Then the second lordship ground which is taken into account is lordship at page 41 observation.
Yes.
Opinion. He is also habituated to remain absent from duty without permission, which is an act of indiscipline. Here, this is a completely foreign charge which is not incorporated in the article, and that a foreign charge cannot be taken into account for giving a punishment.
This is not a charge. This is not a charge.
That was not a charge. But
No, this is not a charge. He was also habituated to remain absent.
Yes.
This is your antecedents.
Antecedent.
Antecedents can be taken into consideration.
But then also, lordship, he was not given any opportunity
There's
for.
no question. The other without permission is an act of indiscipline, remaining absent
Lordship.
earlier occasion.
Lordship. Then also, lordship, I would like to place one. I rely on judgment.
Okay, we'll come back.
Obliged.
It's also a very important matter here, Miller, but I presume it might not work out. Could I have it tomorrow with a liberty to mention for the above list, Miller? It's very important.
Matter of which year?
This is 24. 24. No,
What is
it is on a touchstone. So far as the promotion concern is concerned, we participated and they said I'm not qualified.
What is
and
the
no
urgency?
Urgency is they're coming up with a new one, new promotion. Entire thing goes. One post has been kept preserved, but my right
Not
to
tomorrow, not tomorrow.
day after tomorrow, Miller.
Day after tomorrow.
And I should take the liberty to have an upgrade.
Let us see how many matters are there.
Day after tomorrow, 14.
I do.
The interim is there, no, that may be continued till day after tomorrow.
Who is there for the other side?
Other side, government is there. I'll inform.
Government has to be there here.
I'll certainly
We
inform.
can mention.
Someone will be there. When the matter is called, someone would be there.
But this court is rising early today, 3 o'clock.
Even then, someone would be there. But not that clear.
London. Yes.
Lordship, basically the inquiry officer, without proper analysis and assessment of the witnesses and documents, come to the findings that he was under influence of alcohol, he was discharged, he was misbehaving and misconducting with the other personnel. Now, Lordship, regarding that misassessment and Lordship, the analysis, wrong analysis, I'd like to say that out of the 8 witnesses, except PW5, no one has categorically stated that the petitioner has misbehaved with him or them. And even they said that he was in the witness number 2, he stated that he had been abusing someone on phone. He was informed, abusing someone on phone. So now no one has said, and therefore, Lordship, the misbehaving, the allegation of misbehaving does not arise. And further, Lordship.
So
the
what
pe-
about our W5, witness number 5? The person whom against whom the allegation is there of being misbehaved, he had deposed.
He has Lordship.
He had deposed as.
He has deposed.
Yes.
But Lordship, the PW5, that is the who has deposed Lordship, PW5, he had some bad relation with the petitioner. So, with the intention, he has recorded his conversation. And that recording conversation, neither it has been proved or corroborated by any Lordship forensic or something else. With
In the department proceeding.
yes, that is not required. That is not required.
required.
But the intent, because
Not
Lordship,
required. See, there is one witness, PW, the
5.
witness number 5,
yes,
who is the victim himself. Let us give the
that is the
victim.
misbehavior.
Then 2, 3, 4, 5, 4, 6, 7, and 8 maybe hearsay.
Lordship.
But one has heard abusing someone on the phone. He doesn't know who has been abused.
That-
But in a department proceeding, we don't have
Yes,
the
that
state
is-
rigors of our Evidence Act.
That I agree. But Lordship, the PW5 first provoked him that he was inquiring why his leave has not been Lordship granted even after 1 year. Oh, sorry, 1 month. Then he provoked him.
Where is your allegation of that the PW5 is biased?
That allegation, Lordship, I have written that
Where is the predicate?
in my affidavit, in opposition, I have stated.
Not opposition. In your
Sorry,
writ
affidavit in
petition.
reply.
In the writ petition, you did not state.
In the writ petition, Lordship, about that.
About that, if witness number 5 had some kind of animosity with you and he was biased,
Yes, Lordship.
you have not taken this plea in the writ petition.
Lordship. In paragraph. Yes, that is not. But Lordship, the one thing is that the petitioner was already, by doctor, he has been said that he is under stress and anxiety. And above that, he had some family dispute. So he was asked to cut a book ticket also. He booked also. Lordship, I have annexed one that medical Lordship report in page number Lordship, annexer A, wherein said that petitioner is already under
Mr.
stress.
Tavinder, we are not on that. You belong to a strict disciplinary force,
Lordship.
and your allegations are serious in nature.
Lordship, over telephone, that allegation is misbehaved. Over telephone, he has discussed, Lordship, and it was instigated by him, Lordship.
Threatening of throwing acid on somebody.
It was on the basis of Lordship, he was because PW5 instigated him, Lordship, with him abusing Lordship with filthy languages. So he objected to that. That is nothing more than that, Lordship. And it is not that, Lordship, he has served for more than 14 years of service. Lordship, that punishment is also, Lordship, that is disproportionate. Lordship, any kind of other punishment should have been given to him. And Lordship, moreover, the doctor who has examined him in the affidavit in opposition filed by the Lordship respondents, they have annexed one certificate also. That is also not in a proper manner, Lordship.
Let us see.
At page 104 of the affidavit in opposition.
Yes.
This is the certificate they have produced,
Yes.
wherein it is written that
Found under influence of alcohol.
found under influence of without any Lordship proper procedure and maintain examination, etc. Yes, he was taken there, and they are saying about 19/5/2020 also that of 19/5/2020 incident, nothing has been Lordship said. Only this is of 17/2/2020 this incident. So Lordship, already for other previous incidents also they are stating in their affidavit for which he has already been punished, Lordship. So 14 years of service, Lordship, without any Lordship.
Other incident, what punishment did you receive?
What they have in their affidavit, they have said that already in previous occasions he consumed alcohol and he was punished. This is their statement.
Your antecedents are.
Yes, antecedents they have also taken into account. So my lord, change that. My humble submission is lordship that this the punishment is disproportionate, lordship. 14 years of service and lordship, or that lordship, this serious punishment of removal from service. He is only 37 years of age, lordship. So in such situations, lordship, it's very difficult for him to family, for family also, lordship. Everywhere is suffering, lordship. So and that intoxication part that is there for punishment, that is also less in years, lordship. It's categorically there in the act also it says, lordship. So taking into
For
account
that, the punishment prescribed is imprisonment. You have not even given imprisonment.
that is there. So lordship, my humble submission is that he may be that reinstated and other punishment may be given to him. Any other punishment, lordship, he is ready to accept that. Once he has instigated, he was abusing that person, PW5 was abusing him. He just objected to that he recorded. And he has neither lordship abuse or misbehaved with other persons physically or in during duty or anyway. Nothing has been lordship come out. So lordship, a 37-year-old person, lordship, and lordship discharged 14 years of service since 2006. 16 years of service, sorry, lordship, 2006 to 16 years of service, and that without any lordship temporary benefit, removal is too harsh, lordship. Any other sort of punishment that may be posed on him by the department, that may be lordship of the.
Yes, Mr. Goswami.
Against that order dated, my lord,
Okay, yeah, I'm sorry, sir, I forgot. Again, that order of his lordship, again, he filed appeal, and which was lordship dismissed. Lordship on the, it is saying that this is on the same lordship, the punishment given by the inquiry fishery, lordship, the observation of is correct, lordship, that is at page lordship, page 53. Petition's appeal was rejected. Page 53. They observed that there is nothing infirmity with the order.
50?
53. This is the appeal and departmental appeal file, which has also been rejected. And subsequent, he again filed on revision also.
Where's the revision?
Revision is at page 61. Dated 24th December 2021. They're saying that there is no infirmity with the initial order of removal, so they rejected both that.
Yes.
This is the my humble submission is that the punishment is too harsh, Lord, and that his service career of 16 years that also has to be taken care of, and Lord, if he has further at least 23 years of service left, Lord, may I pray that, Lord, that at least other punishment may be given to. And neither physically abused anyone, nor it was everything was over telephone only. And on the basis of recording of the telephone, the punishment has been. Okay.
Yes.
but it has already been in the witness number 5, my lord, definitely it cannot be acceptable in a disciplinary force like CRPF, such kind of incident, my lord. Against the PW 4, it is clearly demonstrated, my lord. He retained him. So, coming to this kind of allegation that the criminal proceeding has been initiated, in such circumstances, the penalty which has been prescribed under the provision of the group section 11 is adequate, my lord. Because although it is adding as a minor penalty, but there is a my lord, E 1E 11(1)(E) is prescribes that removal from any office of distinction or special emolument in the court. So accordingly, he was found guilty. It was proved accordingly, he was removed from service.
This is not under 11E. Not under 11E. 11E is different, Mr. Goswami. Removal from any office of distinction.
Yes.
Or special emolument.
My lord,
He has been removed from service.
my lord. And in fact, my lord, rule 27 of the rule, my lord, CRPF rule 1955.
That has been followed.
It's required to be, my lord, read along with that rule, my lord.
That has been followed.
Yet, here it is prescribed, my lord.
What do you say about the, he is emphasizing on the allegation that it was only on telephone,
No.
some abuse. Number one. Number two, except PW 5, there is no witness
Right.
which would implicate him.
But PW 5 has been corroborated by PW 6 also, my lord.
Six
Because
says
6, my lord, the head constable,
Putan did not hear.
Tuton Bani,
Putan did not hear.
he mentioned about both of the person's name.
No.
Although
You,
it is,
you read Putan. Putan says that he heard from
Yes.
J. Sinha.
Yes.
Come to W6, witness number 6.
Is number 39. Page number 30.
my lord.
Third line.
My lord.
Please read.
Told me that the voice so the petitioner called him and abused him, saying that he will throw a seat on his and Havildar GD Tutan Bani's eye. He is chasing her, asked the delinquent that what is his problem and why he is behaving such a way, since nobody has prevented him to go to the leave.
Go on.
Only the delinquent did not hear any single word from. It is hard from that case, Jason.
Hearsay.
Yes, but
And he also stated here, no one has prevented him to go to leave. That leave issue is there.
no, fact remains that it is not a single day incident. 2 occasions he is doing it. Initially on 17 to 2020. My lord, well, he was directed, the case rising and Tutan Panik was directed by the officials to bring him to the concerned medical for his examination. That is why the petitioner was against them. And accordingly on that occasion, that occasion, that is 19/5/2020, by telephone, actually he tried to abuse them with filthy language and try to force, but a disciplinary force person, such behavior is not acceptable. And that is why, yes, it is a telephone was recorded, but actually means that record version, that voice was not one of the petitioners. He tried to abuse that another his colleague that way, that he tried to kill him.
What about the proportionality aspect? He is saying that it is harsh, grossly
Well,
disproportionate.
in a disciplinary force, this kind of threatening is not considered to be then it will be difficult to the first person or the general citizen to believe on this person's, my lord. And in support of that decision, my lord, there is an extra 155 page affidavit in opposition. It is a judgment of the Honorable Supreme Court.
Page
155 of the affidavit of opposition. Union of India
155.
versus Ghulam Muhammad Bhatt. So, 155
150?
more. R11 more.
May not be 155. It's 153. 150. $148.
More.
Yes, it is 148.
So designation was
Yes, it is 148 in
What does it say?
no.
What is this decision?
In the here also CRPF case, the background and facts of the case, my lord. The respondent as a constable of Central Reserve Police Force joined duty on Srinagar after being detained from duty from Assam along with the group of press trainees. He applied for leave on 18 January 1992, which was sanctioned. He reported duty after sanctioned leave was over 8 December 1992. The full proceeding was initiated for misconduct and account of was beyond the sanctioned leave period of 3 and 15 without prior permission and sanction and competent authority on so that on the basis of the report of the person, the competent authority passed the order of removal of service. The same as challenge were responding filing petition for the Jammu and Kashmir High Court by the imping judgment that the so learned single judge held that the change the respondent proceeded against ground distinction of the act read with rule 27 of the rule, the order removal without jurisdiction. It was observed that the sanction so only provide for minor punishment, but did not provide for punishment or removal. Accordingly, the order removal, but however, liberty was given to proceeding according to the provision of the act and rule. Well, here, subsequently, the Honorable Apex Court come to fighting the order passed by the interfere with the High Court order. And next, and it's R2, R12. Here also the apex court. In CRPF, yes, here the concerned person was under the conjunction of liquor. He was found guilty and the Honorable Supreme Court upheld the order of removal.
Which paragraph?
Well, next judgment, Maluk.
Now this paragraph in Dalir Singh,
Well, paragraph number 13,
1-3.
1-3. The inquiry officer, as is reviewed from the inquiry report, found that all the witnesses that supported the fact that on so the respondent had gone out of the camp and in the market, he had consumed liquor and quarrel with the local persons, and accordingly has proceeded to hold as under. Thus, it is the proof on so the constable so came out of his Platon and post without obtaining permission from one and consumed liquor. Thereafter, he quarreled with the local persons in the market, and besides above, he by using in indecent language hurled abused this to the personnel present in the camp, and on reaching at company headquarters at so against CRPF persons and officers, which is totally against the conduct and misbehavior of civilized as a civilized and good constable. And the paragraph 22.
Yes.
The learned counsel for respondent has submitted that even if the charges have been closed, the punishment of obtaining factual material is absolutely harsh and shocking on the conscience. It is his submission that the punishment is disproportionate. The respondent was part of the disciplined force. He has left the campus without permission, proceeded to market, consume liquor and quarrel with the civilians. It has been established that he had consumed liquor at the marketplace, and it has been also proven that he has been picked up quarrel with the civilian. It is not expected of a member of disciplined force to behave in this manner. The submission, as has been noted earlier, is that the punishment is absolutely disproportionate. The taste of the penalty has been explained by the court in so other than so. In the Darka Prasad Supra, it has been held that unless the petition is opposed by the disciplinary authority and appellate authority shock the consent of the court and tribunal, there is no scope for interference when the member of the disciplinary force behaves to such an extent from the discipline and behaves in an untoward manner, which is not convinced of,
Conceived of.
conceived of. It is difficult to hold that the punishment dismissal has been imposed is disproportionate and opening to the judicial consent. So, admittedly, here in the state case also, petitioner, his behavior is not appropriate to be not a fourth person. And this is not only a single occasion. Earlier also he has behaved like that. And that is why the punishment imposed upon
You have
him.
the records of the inquiry.
Record is at present not with me. If your lordship, that is, I can bring it for your lordship.
At present means,
My lord, presently, I am not holding that record.
is it in the office, your office?
Office.
Your office.
My lord. Not my office, there is
Oh.
different office, my lord.
Okay, may I submit? The judgments which my learned senior has referred to here is not relevant in our present case, because the initial judgment at 148, the judgment of lordship that at R11 lordship, wherein that was a case of overstay of plea. That is a serious offense, overstay. Even after repeatedly, if he overstays without informing or without causing reason, that is different. That is the indiscipline that is not related with our present case. And the second judgment, where also, yes, consumption of liquor is there in that case, delayed. But here he quarreled with the civilian, and he lordship went away without permission. He left the camp without permission. Both are the very serious judgment, and that cannot be equated with the present case. Here, lordship, only over telephone, he said PW5, because he instigated him, he said, you give my leave because of my anxiety. I have my family dispute is there. I have already applied, and you had asked, authorities has asked me to book ticket, which I booked also. But instead of giving my leave, granting me leave, they were granting leave to other persons. So when he was instigating, he objected to that. And the intention to lordship, intentionally that recording has been done. And no one has said that, like in the delaying case, you quarreled with someone, but he didn't quarrel, or neither he misbehaved with the other officials or personnel. But in these two cases, which my learned friend has those are completely different and serious issues. The orders just simply lordship over telephone, may it be disciplinary force over telephone, saying something out of anxiety and stress. I have annexed the medical certificate also that he is suffering from anxiety and stress. At page lordship may page the doctor's certificate, which is annexer A to my petition.
Page
24. He was already from previous occasions, he was under stress and anxiety, and over family dispute, everything was there. And the other witnesses said they heard he was talking about with someone, with other persons with whom he was misbehaving. Nothing has been clearly said. Page 24, that is at left side, let's say anxiety and stress. He has been suffering since 2017. Yes. So
anxiety and stress.
Not it. Yes.
Anxiety and stress, these are
common, that may be common, but because of the family dispute in 2020, that is also, he has never confronted anyone that physically that you come, PW, you come, because the reason is that he was not given the leave, he was just objecting to it. For such incident, the punishment, it is a very serious punishment, removal, and he is in the right, he is in the age 37 years of age only, and already discharged third duty without any complaint from any quarter. All the incident happened in 2000, started happening in Rani when he was posted. For initial 11 years, nothing was there. No complaint. Once, because PW5 had not good relation with him, and he recorded it intentionally. See, he joined in 2006, petitioner joined in 2016, 17. Situation when he was posted in Rani, no complaint, nothing such decisions was. So Lordship, may I pray that at least Lordship, this punishment of removal can be Lordship, that is disproportionate and shockingly Lordship. It cannot be Lordship. Are there any other punishment that Lordship that may be prevent to him?
Difficult. Yes, we'll close this then. We'll close for you. Yeah, Builder. UK question. Robert Alukdar is Builder. Okay. We're reserving the judgment.
Lord. Obliged, Lord.
Yes.
The matter relates to non-payment of salary, Lordship. Since October 2014, Lordship.
You are working as what?
Working as vaccinator. And
Where?
now in Jorhat, Lordship. Jorhat. Joint Director of Health Service, Lordship. Initially was vaccine
Your name is S.J. Sharma?
as a summer.
Yes, what happened? You are vaccinated at Jorhat. Then what happened?
There an FIR was Lordship in this regard, Lordship.
FIR for what?
FIR that these are fake appointments, Lordship, made. And FIR does not contain my name, Lord. FIR is at page 3, page 12, Lordship, and except 3.
Page? FIR at page?
FIR is at page, Lordship, 12, Lord, and except 3.
Yes. 7/5/15.
Yes, 7/5/15.
Yes. Then what happened?
Then, Lordship, an inquiry was conducted. Affidavit in opposition filed by Joint Director of Respondent number 3, Lordship. There in the affidavit, the documents made annexer. My name is shown as list of doubtful appointments.
Page?
My name is at page. Affidavit, affidavit filed by respondent number 3, page page 5, Annexure page 5, Lord.
Hmm. But this is the transfer order.
11, Lord. Please, page 11, Lord.
11.
Okay, two affidavits are there, Lord. One filed by additional,
You're
Respondent number-
referring to the additional affidavit or the affidavit?
additional affidavit in opposition by Joint
Okay, then
Director
we
of
have-
Health Service.
We have that. We have that, don't worry. Page?
Page Lord tape 11, Lord.
Yes.
The petitioner name is Lakshya Harika, vaccinator.
Hmm. How many petitioners are there?
One petition.
Okay. Yes, date of birth since October. No record of salary. Yes.
In that affidavit, page 6, Lordship.
Hmm.
The Deputy Commissioner, their submission of list of suspected employees and observation made by the inquiry committee.
Hmm.
Lordship, in the last part is out of 32 employees, 9 could not give their documents before the inquiry committee, Lord.
Hmm. Paragraph 6.
Page 6, Lordship, Annexure B. In their affidavit, Lordship, filed by the
Yes.
The observation, Lordship, after scrutinizing their documents, it was found that some appointment letters were issued from DHS Assam, which we could not verify, and it can be verified by DHS Assam or concerned higher authority to ascertain their authority. Those appointment letters were issued by joint directors of different and districts up to 2005, which we could not nullify, Lord. As per the government memorandum before 2005, do not require SIU, Lord. The financial occurrence was to be verified at the beginning of financial year. The employees got salary up to September 2014.
You got salary up to 20.
2014, Lord.
When were you appointed?
Initially appointed in 11 to 2005, Lord.
Yes.
Inquiry was conducted and remarks were passed on 31/8/2015, Lord.
Yes. You are seeking a direction for release of your salaries from October 2014.
Okay.
Are you working now?
Okay, from 2017. Okay, 2017. Okay. 2020 to 2017, Lord. From there, what I was given to sign a register with a single documents, Lord. Only me. After that,
I continued for 5 months and I did not continue.
That means from which date?
From from May, Lordship. May last I could not continue.
May which year?
May 2017, Lord.
After filing of the writ petition?
No, after repetition was filed in 2016. Lord.
16, after filing of the writ petition?
Yeah, after filing.
That means your claim would be confined to October 2014 to May 2017,
2017.
around 2 years, 8 months. And in that period, you had rendered service.
Service.
Yes,
I wish to continue from there also, but the circumstance was that the service will render no benefit.
Well, here it is a fact that my lord, in my lord 2014 and 15, an inquiry was conducted, especially in the district of Jorhat and Dibrugarh by the CM Vigilance Cell. And that report, Lordship will find my lord remarks against the present petition at page 11 of the affidavit filed by respondent number 3. Page number 11 of the affidavit filed by respondent number 3.
Yes.
Joint Director
so
Jorhat.
that we have seen, that is not
But
conclusive.
here, what we have found is that, my lord, on record, there is a transfer order. He has joined in Jorhat from Dibrugarh.
Yes.
But, my lord, the service rendered in Dibrugarh, my lord, there is no such detail to show that, my lord, even he has got the salary there. So that part is, my lord, doubtful. Now, my lord, after the inquiry, the entire records have been placed before the CM Vigilance. We are not in possession of those records. As a result, my lord, we have not been able to ascertain, my lord, this genuineness. We have to submit it. And this fact has been, my lord, placed by the director, affidavit filed by respondent number 2 in para 2.
No, are you been able to get hold of this official order of Dibrugarh of 2005 by which he was appointed?
But that otherwise, my lord, yes, that is there, my lord, in the writ petition here and next.
See, in surveillance worker case, we have
Yes.
committed many anomalies. They were equipped with transfer orders.
Yes, my lord.
But here, only because in surveillance something has happened, we cannot presume.
No. In fact,
These are-
no, my lord, in the my lord, for grade 3 and grade 4 also, there was an inquiry conducted subsequent to my lord surveillance worker.
Okay.
More than my lord 300-400 my lord grade 4 employees have been terminated. My lord, the single bench has my lord upheld the termination. Now 1 or 2 district has now approached the division bench. Rest have my lord has accepted the verdict of the honorable court.
Now, the petitioner claims that till September 2014,
Lordship.
he has got the salaries.
Yes, it was given thereafter, my lord, the government, my lord, in the health department instructed that whoever has been found to be doubtful, salary should not be released.
Now, have you made any statement or any remark on the issue that he had continued till May 2017?
That part, my lord, probably not there.
See, your inquiry is not conclusive.
Not conclusive, yes, my lord, apparently. My lord.
And Mr. Sharma has candidly disclosed that from 17, he is not continuing.
Lordship.
So remains his 14 to 17. Now asking you to make a verification will not make any meaning. Because your verification already done.
Verification to the extent, my lord, of service rendered by the petitioner.
Yes.
On his own. He voluntarily, my lord, did not, he discontinued his, my lord, service.
No,
Because
if there was a discontinuing, if there was an order to discontinue and yet he continued, matter would be different. His discontinuation is from May 2017.
Yes, ma'am.
We are on the
Till that
period
part.
of October 24 to 14 to May 2017.
Lordship. Then in that case, Lordship will indicate, my lord, Lordship will direct the authority to verify only that part.
That
From-
part,
yes.
that part, that
If he has worked, my lord, that salary should
that
be
part,
paid.
that part, that part. And since subsequent petition has not been filed,
Yes.
for either challenging the discontinuation or directing for a
Or even a
continuation.
miscellaneous application, my lord, praying for some protection that during the pendency he should be allowed to continue. No, my lord, steps was taken.
That was.
Lordship, a similarly situated person, Lordship. That is, I have provided the order, Lordship.
Yes,
909 WBC.
yes, yes. What has been given?
And because the similarly situated person, Lordship, similar order may be passed, Lordship. In reinstatement, if he goes to works, he is not given to sign the document.
No, no,
Lordship.
this cannot be a similar order.
Yeah.
Here, there is no question of any challenge to a removal order. In your case, you have not challenged any order of discontinuation or removal, so question of reinstatement will not come. You are only paid.
Then
Let
let
them
me.
verify
because-
for
Yes,
May 17 to October 14, for October 14 to May 17. And if it is found that you are in fact rendered your service, your salaries have to be released. Okay. Okay.
Since no departmental inquiry or I may be allowed to join, Lordship.
That is, you had on your own volition from 17, you are not there. After 5 years, what 5 years? More 7 years, can we direct
Yeah.
joining? You have to make a specific prayer. This was filed in 16, subsequent development of 17. You can come up, you should have come up. Okay, other matters may not be possible today. This court is rising at 3 o'clock. They were dictating this after the third, 3 H.J. Sharma, learned counsel for the petitioner. Full stop. Also heard 3 B. Gogoi, learned standing counsel, Health and Family Welfare Department. Full stop. Para. The writ petition has been instituted for the following relief. Court Kurijiba, page 6-7. 3 Sharma, the learned counsel for the petitioner has submitted that the petitioner was appointed as a vaccinator on 11/2/2005 and was initially posted at Dibrugarh. Full stop. Subsequently, he was transferred to Jorhat, where he was discharging his duties. However, the salaries were stopped from September 2014 without any reasons. Full stop. He had filed the writ petition in the year 2016 and had continued in his service till May 2017, whereafter he was not allowed to continue. Full stop. It is submitted that the petitioner's entry into the service was not clouded, and therefore the petitioner has a legal right for the salaries for the period in which he had rendered his services. Full stop. Learned counsel for the petitioner has also informed that there has been some enquiries on certain fake appointments. Full stop. However, so far as the petitioner is concerned, his appointment would not fall within those fake appointments, and therefore, appropriate directions be issued. Full stop. Para. 3 B. Gogoi, the learned standing counsel has submitted that in the year 2013-14, detecting certain anomalies in matters of appointment in the Health and Family Welfare Department, more particularly in the district of Jorhat, an inquiry was conducted by the CM's Vigilance Cell. Full stop. In the said inquiry, the name of the case of the petitioner was also examined and it was found that there was no record of payment of salary from the date of appointment. Full stop. The Standing Council has referred to the document annexed to the affidavit in opposition filed by the respondent number 3 on 28/11/2016. Full stop. So far as the petitioner is concerned, comma, his date of appointment was stated to be 2/11/2005 and his date of transfer to Jorhat was in the year 2011. Full stop. As regards the salary status, comma, it has been stated that till October 2014, comma, salary was given by the Joint Director of Health Services, Jorhat. Full stop. From the said document, comma, it appears that the petitioner had also it also appears that a service book was also opened for the petitioner. Full stop. Para. Sri Gogoi, the learned Standing Council has however submitted that for further verification, comma, all the documents have been handed over to the CM Vigilance Cell and the matter is yet to be and the matter is yet to be finally settled. Full stop. Para. Though the learned counsel for the petitioner has also raised the issue of discontinuation from service from May 2017, comma, in absence of a specific challenge in the writ petition, and that being a subsequent event, comma, this court will not embark upon that issue. Full stop. Para. So far as the claim for salaries is concerned, comma, it appears from the pleadings and from the submissions that from October 2014, the salaries of the petitioner has not been paid. Full stop. The learned counsel for the petitioner has informed, comma, as observed above, that from May 2017, comma, the petitioner was not allowed to continue in his service. Full stop. Since such action is not the subject matter of challenge, comma, without making any comment on that aspect, comma, this court directs that the claim for salaries for the period October 2014 to May 2017 be examined by the authorities, and if it is found that the petitioner had actually rendered his service for the said period, comma, these salaries are to be released to him expeditiously and preferably within a period of 4 months from the date of receipt of a certified copy of the order. Full stop. The respondent authorities are also at liberty as to whether to continue with the service of the petitioner, taking into consideration the long period of service, long period of experience attained by him from the initial date of appointment in the year 2005. Writ petition stands disposed of.
Obliged. Obliged.
শূন্য নহব। This you can take it back, Mr. Sharma. Others, dates will be given. Today, we have to rise early.
But in item number 21 and 22, Lordship, there is some urgency in this matter, Lord.
Did,
Lordship, one observation may be given, liberty may be granted to update this child, Lord, on the next petition.
what is the urgency?
Lordship, petitioner was dismissed from service, Lordship, and he was 1 year left for his retirement, Lordship.
We'll have it, but no such observation. Date of the DDP. Any matter, dates.
May-
will be given.
Please, dear Lordship, Lordship, item number 14, my senior colleagues also mention is. Lordship, interim is there.
14. 14, who is for the government? 14, day after tomorrow. Huh? Interim order passed early, huh? On request of Sri Bonik, learned counsel for the petitioner. Please, day after tomorrow, interim order passed earlier to continue to the next day. Mr. Goswami, anything?
Item 12, Lordship. But Lordship, any other day, Lordship, because petitioner is now retired from service and he undeterred because
Yes, it was early did you?
Item 31 date may be given, Lordship.
Which one?
Item 13, Lordship.
He'll give date.